do believe, yes, for officer safety, they do have the right.
Doesn't there have to be reasonable suspicion that the person committed a criminal offense or violated a law?
As I don't know the law exactly.
What lawful basis was there for you to ask for her ID?
I don't know.
In order to detain somebody, what do you have to have legally? Do you know?
I do not know the law legally.
Okay.
In a quiet corner of Cook County, a seemingly routine incident spiraled into a shocking display of ignorance within the ranks of law enforcement. This is the story of Samantha, known as Pink Camera Magic on YouTube, and her encounter with two cops who don't know the law. It all began when Samantha stood outside the Cook County courthouse, her camera in hand, recording the imposing structure before her. Lieutenant Malazzo, a 20-year police veteran, confronted Samantha, asserting that recording the courthouse was prohibited by a judicial order. Samantha's request to see the order triggered a sequence of events that would later be deemed unlawful.
Hey, ma'am, you know this is a public building?
Exactly, that's why I'm recording it.
It's also a court facility?
Yep.
Which there is a judicial law or judicial order that says that you cannot tape this building.
Can I see that order?
Yes, come on in. We're going to check your IDs too.
Oh, no, I'm not going in.
Oh, yeah, no. We're going to run you too.
No, that's all
We're going
right.
to get your name. We're going to do a report and everything. So come on in.
No.
No, yeah, you're going to come in now.
Am I being detained?
Yes.
For what?
Because right now you are doing something suspicious.
That's not a reason to detain anybody.
Well, it is for Dana. Come on.
It's really not.
Let's go
So
inside
I'm just going
now.
to stay here and continue recording.
Okay. You're going to come in and we're going to find out who you are and what you're doing here.
No, you're not.
Okay. All right, who's got cuffs? She does not want to go agreeably.
Samantha's refusal to provide her ID raised a critical question. What lawful basis did the officers have for this demand? Before a police officer can properly stop a person and ask for identification, the officer must have a reasonable, articulable suspicion that a crime has occurred. In the beginning, Lieutenant Malazzo said this.
Hey, ma'am, you know this is a public building?
Exactly, that's why I'm recording.
It is stated clearly that taking photographs and video of things that are plainly visible in public spaces is a constitutional right, and that includes transportation facilities, the outside of federal buildings, and police and other government officials carrying out their duties. Recording in public is not a crime nor a reasonable suspicion to detain someone.
Okay.
I'm being detained for just taking pictures of the building.
Yes, ma'am. You're doing something suspicious and we need to know who you are and why you're doing it. Okay?
Are you familiar with the First Amendment?
Yes. I am.
Really?
Let's go in. Come on.
Wow.
I tried to do this nicely.
To demand someone's ID, there must be reasonable suspicion of a criminal offense. Samantha's recording of a public building didn't meet this criterion. The officers' actions escalated as they detained Samantha, citing vague suspicions as their justification. Officers should have known that mere suspicion doesn't warrant detention. It must be based on specific, articulable facts. In a disturbing turn of events, the officers mocked Samantha after she invoked her right to remain silent.
Lawyer.
Okay, call your lawyer.
That includes my camera as far as consent.
It's already on.
Are you familiar with the Fourth Amendment?
Oh, great. Why do we always get the crazies?
I don't know. Did you delete my footage?
Do you want to cooperate or not?
I'm remaining silent.
This is your choice. You can either give us an ID so that we can do a report on this and find out who you are, or we're going to take you in front of the presiding judge. He's going to hold you in contempt, which means that he can hold you for as long as he wants.
I'm remaining silent.
Okay, that's good. Okay.
Yes.
We're going to probably take her in front of the judge.
Okay.
He's going to hold her in contempt for, I think right now he's doing 90 days.
Okay.
So, is that okay with you?
Remaining silent.
Okay, but you realize you're going to go to Cook County Jail for 90 days.
Remaining silent.
Okay.
Okay.
Now you have an option. All you have to do is show us an ID so that we can do a report, and we'll let you go on your way.
I have an option?
Okay?
We told you that before.
Because right now you're just obstructing.
I'm in the elevator right now.
Obstructing what?
You're obstructing us from doing our job.
I'm remaining silent.
All right, cuff her. Let's get her purse.
Ken.
Get her stuff.
I don't consent to searches.
Well, we don't care anymore.
Mocking a person's legal rights is unacceptable and unprofessional conduct for law enforcement officers. Samantha's camera was confiscated, and the situation intensified as Lieutenant Malazzo insisted on her providing an ID. Samantha's decision to remain silent led to an ultimatum from the officers: provide an ID or face detainment in front of a judge. Samantha was handcuffed and arrested, sparking a legal battle that would expose the officers' egregious actions. Arresting someone without a valid reason is a clear violation of their constitutional rights. During the deposition, Lieutenant Lieutenant Milazzo's lack of legal knowledge became painfully evident.
What would you do if one of those people said to you, what's the difference between arrest and detain? What would your answer be?
Call legal.
Mr. Gorman, seated to your left?
No. Sheriff has their own legal.
Oh, okay. Their own legal who helps them understand things like the difference between arrest and detain?
Yes.
Gotcha. Was there a lawful basis to handcuff her?
Yes.
Okay, and what was that lawful basis?
Officer safety.
Are you familiar with the Fourth Amendment, by the way?
Vaguely.
What does it say in your own vague terms?
No illegal search and seizure.
All right, unless there's,
Probable cause.
or,
That's about all I know.
okay, all right, good enough. You said that's about all I know.
Lieutenant Milazzo's inability to comprehend basic legal concepts left a trail of unanswered questions.
All right, now, there was somebody else who asked you the same question that I just asked you about your familiarity with the Fourth Amendment, who's in this room right now. Do you know who that person was? My client. Ms. asked you that, didn't she?
I don't recall.
She asked you, are you familiar with the Fourth Amendment? You don't remember that?
No. Well, it's already on.
Are you familiar with the Fourth Amendment?
Oh, great. Why do we always get the crazies?
I don't know.
If I tell you that your answer was, oh great, why do we always get the crazies? Would you dispute that?
No.
Does that sound like something you would say to somebody?
That's something I did say that day, yes.
So you remember saying that?
Yes.
Okay. Do you remember saying that in response to the question, are you familiar with the Fourth Amendment?
No, I just remember saying it.
Why is it that you felt she was one of the crazies?
When people act in a way that is not in their best interest.
How is she acting that was not in her best interest?
Well, at any time, all she had to do was identify herself. We could have done our report and everything could have gone the own.
Is there a law that requires people to identify themselves when requested by law enforcement?
I don't know.
Have you ever read anybody the Miranda rights?
No.
You've never read anybody their Miranda rights?
No.
Even the fundamental Miranda rights seemed foreign to Lieutenant Milazzo. This shocking revelation cast doubt on his qualifications as a law enforcement officer. Both officers struggled to provide coherent responses, leaving their actions further exposed as unlawful. Officer Larson's deposition revealed similar shortcomings in her understanding of the law.
Is it against the law to take pictures of a courthouse from outside?
No, not that I know.
Okay. Is it lawful to arrest somebody for taking pictures outside of the courthouse,
No, not that I know.
Okay. Are you familiar with this case at all?
Which case?
The case that brings us here today, that you're testifying in?
Yes.
Okay, and in a nutshell, what's the case about?
I would say that Amanda is, I guess I called you to say that she was outside videoing when she shouldn't have been. So she's saying we violated her amendment rights.
You're correct. When you say when she shouldn't have been, what does that mean? Was she doing something wrong?
Just something unusual, what us as officers would consider unusual.
In order to detain somebody, what do you have to have legally? Do you know?
I do not know the law legally.
Police officer goes over to somebody on the street. Let's call the person Mr. Plaintiff.
Okay.
Police officer goes to Mr. Plaintiff and says, hey, let me see your ID. And Mr. Plaintiff says, no. Is the officer now allowed to put Mr. Plaintiff in handcuffs and detain him?
I do believe, yes, for officer safety, they do have the right.
Doesn't there have to be reasonable suspicion that the person committed a criminal offense or violated a law?
Because I don't know the law exactly.
Lieutenant Milazzo's inability to grasp crucial legal concepts raised serious concerns about his competence. As the depositions continued, the officer's lack of legal knowledge painted a disturbing picture.
You just said that he asked you for the memory card because he wanted to delete the pictures. Is that your testimony?
Yes.
Okay. And if he were to testify at some point in time that he absolutely, categorically did not delete those pictures, then would you want to change your answer as to whether you or one of your people did?
I'm going to object, calls for speculation.
No one had custody of the camera but me.
Okay. Would it have been lawful for you to delete her pictures?
I don't know.
What do you think? Are you allowed to go over to people's pictures and delete them?
No.
Without a court order?
No.
Right. That would be a violation of which amendment, do you know? What do you do if somebody says they want to talk to a lawyer and you have them in handcuffs?
We allow them to call a lawyer.
Do you keep asking them questions?
It depends on the case.
Oh, I got you. Okay. Tell me the case in which you would continue to ask questions of somebody in custody after they ask for a lawyer.
If we're doing an investigation, we're going to ask.
I got you. Okay. Do you know which amendment it is that allows people to demand a lawyer? Do you have any idea?
No.
When you arrest somebody, do you have to advise them that they have the right to remain silent?
Yes.
Do you have to advise them that they have the right to an attorney?
Yes.
Do you have to advise them that if they cannot afford an attorney, one will be provided to them?
Yes.
Okay. Now, what if somebody says, yes, I want to talk to an attorney? Do you get to keep asking them questions? Or do you have to call a lawyer for them before you want to ask any more questions?
I don't know.
You don't know? You don't know if you're allowed to keep asking questions of somebody in custody after they ask for a lawyer?
No.
How long have you been employed at Cook County Sheriff's?
27 years.
27 years. I imagine you only became a lieutenant recently?
No.
How long ago did you become a lieutenant?
22 years ago.
You've been a lieutenant for 22 years and you don't know the Miranda rights?
Samantha's legal battle against Cook County remains ongoing, but her case has already exposed a staggering level of ignorance within the ranks of law enforcement. In a world where knowledge of the law is paramount, this case stands as a stark reminder of the importance of upholding citizens' rights and holding those responsible for their actions accountable. If you want to watch more police cam stories, subscribe and turn on notifications for more. Enjoy the next video.
When he approached that front door, he could have said Fort Worth Police, and Tatiana would still be alive.
Does the defendant tell you that?
Not to my knowledge.
Someone lost their life. He's supposed to be testifying in his own defense, and he's cracking jokes from the witness stand. Is your gun, that Glock, is that a firearm?
Yes.
Is a firearm a deadly weapon?
Yes.
Aaron Dean's path to becoming a police officer was questionable from the beginning. When applying for the Fort Worth Police Department, Dean failed his psychological exam, which highlighted his narcissistic personality, impaired decision-making, and interpersonal challenges.
Be able to kill somebody if you have to. No problem.
Despite these red flags, the department still hired him. It became evident that these psychological shortcomings would play a significant role in his career. On October 12, 2019, Dean and his partner responded to a non-emergency call about a house with the lights on and the front door open. Rather than announcing his presence, Dean chose to stealthily circle around the house, peering through windows. This decision escalated the situation. Police officers are generally required to announce themselves when entering a home, a principle known as the knock and announce rule. This is a standard procedure in most jurisdictions and is backed by the Fourth Amendment, which protects against unreasonable searches and seizures. Exceptions can be made if officers believe announcing would lead to destruction of evidence or put someone's safety at risk. However, this cop is not here for anyone's safety. Jefferson, hearing someone outside, grabbed a weapon and opened the blinds. Without hesitation, Dean fired a single fatal shot. He hadn't identified himself as an officer, nor given any warning. The lack of proper procedure resulted in the unnecessary death of an innocent woman in her own home.
Put your hands up! Show me your hands!
During the trial, Dean's personnel file revealed troubling patterns that had been overlooked. A supervisor noted that Dean had tunnel vision and would often fail to follow instructions. In 2004, he had been cited for inappropriately touching a woman without her consent and asking her not to report it. Despite this history, Fort Worth police allowed him to serve in a position of authority, highlighting significant lapses in their vetting and accountability processes. During the trial, Aaron Dean took the stand, but it quickly became apparent that his defense was crumbling.
Have you been dispatched to open structure calls in the past in your career where you've identified yourself out loud verbally as Fort Worth Police?
Every call is different, but yes, there have been some.
And there have been burglary calls that you've been dispatched to where you verbally announced yourself as Fort Worth Police, isn't that correct?
Again, there are different types of burglary calls, but yes.
So, all that stuff that's stacked up, the lawnmower, the weed eater, the bicycle that's being stacked up by you think the bad guy that's there in the house. Did you ever confirm the license plates of the cars to see if they did belong to the owner?
No.
Wouldn't it have been a good idea to determine if one of the license plates did not belong to the owner of the home, so you could maybe identify if your imaginative perpetrator had a getaway car outside?
At the time, both of the cars matched the description that said they were supposed to belong to the house. I then turned my focus to the house to see what was going on in the house. I'm sure.
So you had no reason to think that anyone that shouldn't have been in that house had a car parked in that driveway?
Not at that point.
Well, did you just expect the burglar to pick up the lawnmower and the weed eater and the bicycle and carry it under their arms down the street? Where was the getaway car?
There could have been someone coming.
Could have been someone coming. Did you leave someone in the front yard and watch and see when they showed up?
No.
That would have been a good idea, wouldn't it have?
Objection to sidebar.
Stay.
Was that good police work to leave no one out in the front yard to see if the getaway driver was coming?
Objection, asked and answered.
Overruled.
It could have been better.
Was that good police work?
Objection, asked and answered.
Sustained.
So, can we go back to playing the body cam footage, Your Honor?
Yes.
I don't.
So there is no way for you to know who was, that if Officer Darts was behind you whenever you're up at that window, is there?
I trusted that she was standing behind me like we were trained to do.
But you have no way of knowing that night that she was behind you, do you?
If you're asking if I felt her, no, I did not.
And you don't have eyes in the back of your head, as you already said, so you did not know where she was, did you?
Again, I trusted that she was behind me like we were trained, but no, I don't know for an absolute fact.
The prosecutor's cross-examination was relentless, methodically exposing Dean's poor decisions and lack of professionalism. The lawyer systematically broke down this self-assessment, pointing out the numerous breaches in protocol, failing to secure exits, not calling for backup, neglecting to inform his partner about seeing a gun, and recklessly entering the house.
Ladies and gentlemen of the jury, I guess it's inherently dangerous to sit in your own bedroom, in your own home, in the middle of the night, while you're babysitting your 8-year-old nephew. Because she's the one that's dead, not the defendant. And all this talk about training and self-defense, it's not the defendant's point of view. You will not see anywhere in this charge that you're to look at it from the defendant's point of view. You're to look at it from a reasonable person in the same circumstances. Well, you know who was in the same circumstances as the defendant, who was looking death in the eye? That was a Tatiana. Did she fire? No. He did. And we're going to talk about it here in a minute. You're going to see that he didn't even see a gun. But let's talk about how we got there on October 12th. 2019. Because let me tell you, the one person that had no input on any choices that night was a Tatiana Jefferson. Not one choice as things unfolded. Because on October 12th, 2019, when the defendant was called to her house, he was the one making choices. When he approached that front door, he could have knocked and Tatiana would still be alive. When he approached that front door, he could have said, "Fort Worth Police," and Tatiana would still be alive. The general orders are here for a reason. They're here to guide these officers so they get home safely and the citizens of Tarrant County of Fort Worth are protected and served. Tatiana Jefferson was not protected or served on October 12th, 2019. The defendant's own words. They want to argue about Dr. Priest, or Mr. Priest, or Dr. Coons. Dr. Coons couldn't answer a question. If I would have asked him if the sky was blue, he would have said, maybe, perhaps, there are other factors. The man couldn't answer one straight question. What does that say about his credibility? the defense's witness, wouldn't even answer one question after he saw the defendant time and time again sitting in that seat, look at you under oath and say, that was some bad police work. That was some bad police work. Dr. Coons watched him admit bad police work over and over again, then stood up here and told you he did everything great? The defendant knew he didn't do everything the right way. And when you look at the general orders for silent alarms, because that's what you can look at, it's in the exhibits. It says, if you see signs of damaged entry, you shall call for backup. What did the defendant tell you on Monday? I thought the window had been, the screen door, there was damage. Someone had broken in. There was a screwdriver right next to the door. That's signs of forced entry. Signs of forced entry. His general orders say, at signs of forced entry, you shall call for backup. But he ignored that. Because, you see, you know who the defendant really is as he testified. You know. I mean, he cracked a joke. I guess I just should have stayed home that night. Someone lost their life. He's supposed to be testifying in his own defense, and he's cracking jokes from the witness stand. I guess I should have just stayed home that night. Well, Tatiana was home, and she's no longer here because of what he did. The choices he made, the choices that she had no input into. She, the defendant, did not call for backup when he saw that second screen door, even though it was in his general orders to do it, shall do it.
The lawyer pointed out that Aaron Dean didn't even tell his partner there was a gun inside the house after shooting. He allowed Officer Darch to enter the home without warning her of any potential danger. The lawyer emphasized that Dean only said, "Looks like we have a weapon here," showing he wasn't sure of what he saw when he pulled the trigger.
So he kept going, because that's who he is. Gung-ho, hard charger. Ignoring his own safety, ignoring Officer Darch's safety, he leads her into that backyard. And I guess Dr. Coons says if you don't want the police in your backyard, you better lock your gate. All of Fort Worth better go lock your gates right now, or I guess the police can just go in your backyard whenever they want to. Or was that as ridiculous to y'all as it was to me? We have a reasonable expectation of privacy in our homes, just like Ashley talked about. Just like you know, home is where you feel safest. Home is where you know you can protect your family. Home is where you know you can care for your nephew while your mother's in the hospital. But the defendant didn't care about any of that. He was going to get in that backyard. Regardless of that front entryway being completely open, anyone that was in that house could have taken off running. Anyone in that house could have come back around and shot him in the back. He wouldn't have known it because he didn't care. He didn't care about the general orders. He doesn't care about who's in that house. He's a hard charger. He is gung-ho. He was going to get in that backyard. And Tatiana's sitting there playing video games, watching Zion, knowing that this defendant is making life-ending decisions, and she can't do anything about it because she has no idea. So now they get to the gate, and he opens the gate, and they get inside, and they get to that back window. He'd been shining his flashlights all over the cars, shining his flashlight in the back window. Now, again, it's a reasonable person, but I want each of you to think, what would you do in the middle of the night if you heard a noise in your backyard? And your children, your grandchildren, nieces or nephews, whoever it may be, are there with you. And you know that you are the only line of defense for their protection. And you hear that noise, and you see a flashlight in your backyard, and you know that you have a gate and a fence that's protecting your backyard. What would you do? You would do the same thing that Tatiana did. She's in her own home. she sees somebody she doesn't know in that backyard. Zion's on that bed. And she knows that she's the only person that can protect Zion from what's happening in that backyard, because don't forget, she had no idea what decisions the defendant had made up to that point. So yes, she gets her gun and she goes to that back window and looks. And they want to make a big deal about Mr. Priest. That case, that man was given commands, and that man had the opportunity to observe those commands, and that man did not. I want you to remember how long their video expert said was from the beginning of the command to the shot was fired. Half a second. How was she supposed to comply? What was she supposed to do? And pointing a gun at a Fort Worth officer is illegal? Yes, it is. If you're violating the law. She didn't know who was out there. She didn't call the police, and she had no input on any decision he had made up to that point. She was there to protect Zion, and that is all. Her only crime was love and protection of her nephew, not pointing a firearm at the Fort Worth Police Department. So he's at the window, and you watch it. Take the body cam back. Watch it over and over again. Look at the audio. Half a second from the first command to where, and it's put up your hand, show me, bam. Half a second. No one can comply with that. No one. She never had a chance. So now we're at the window. And they brought this videographer guy in here and all this other stuff. But let me tell you, there's a lot of evidence that shows this man never saw that gun. He didn't know what he saw. He just shot. He didn't shoot 2 or 3 times to make sure that the threat was over with. He shot 1 time. And their expert, one trial, he's saying it takes a second, a third, a second and a half for the brain to make a decision and for your hand to react. But no, this one's different. This one's different because it's a different case. Or is it because it's a different legal theory? When the defense attorney gave his argument just a minute ago, he held his hands up like this. If her hands were in front of her face, they would have been hit with glass. They would have been hit with glass, and you would have saw the same injuries on her hands and forearms as you would have saw on her face. They're not there. You know why? Because the gun was down. Because she didn't know what she was looking at. The defendant testified she was bent over almost perpendicular to the ground. And then the videographer said she's up straight. Well, she couldn't have been up straight if the bullet enters here, like the defense attorney just said, and is found down lower just past her right kidney in the back. She was bent over. And Zion testified the gun was in her right hand. Use your common sense. You didn't lose it whenever you walked to those metal detectors. How must she have been standing? She's standing like this. If she would have had the gun up like this, she would have had glass. If she had the gun in her hand, it was down. He didn't know what he saw. And where is the green laser you were promised last week in opening statements from defense attorneys? I want you to remember, the defense attorney stood up, looked you in the eye and said, you will hear testimony that that green laser hit his chest. Not one person from the witness stand, including the defendant, was able to tell you under oath that that green light hit his chest. You know why? Because he didn't see it. So now, let's take a look at what happened after he pulled that trigger. Because I tell you, what he did after he pulled that trigger shows you, beyond a reasonable doubt, that he committed murder and that he didn't see that gun. He didn't know what he saw. He saw a silhouette.
Line of argument, because the jury's job is to view this case from the standpoint, according to the charge, of a reasonable and prudent person at the time, not in hindsight.
The jury has been instructed. Your objection is overruled.
He didn't know what he saw. And you're going to hear it here just in a minute as I explain it, because you probably already know. You know because you heard the testimony when he saw this silhouette, and you can take into account what he did afterwards as evidence of what he knew.
I have a running objection.
You may.
You can take into account what he did afterwards as to what his intention was at the minute, the second he pulled that trigger, that half second.
During his time on the stand, Aaron Dean did not appear to show any remorse for his actions. Despite having fatally shot at Tatiana Jefferson in her own home, Dean ultimately pleaded not guilty to the charges against him. His demeanor remained detached, raising questions about his understanding of the gravity of the situation. In a critical moment of the trial, Dean's partner, Officer Carol Darch, testified against him. She revealed that at no point before or after the shooting did Dean mention seeing a firearm or say the word gun, undermining any justification for the lethal force used. This testimony further exposed inconsistencies in Dean's defense, painting a clearer picture of the unnecessary escalation that led to Jefferson's tragic death.
All right. So y'all go around and go into the front, and then you go inside, and I hear your voice before his making some announcements of some sort.
Yes, ma'am.
Do you remember what you said?
From the video, I said hands up.
Okay. And why are you saying hands up?
I can't tell you exactly why I said hands up. I don't know if I was in a heightened state of adrenaline, and that's the last thing I heard, so I said it too. But I wanted to announce that we were coming in the house.
Get back into the back bedroom. What is your priority when you get back there? What do you do?
As soon as I came through the door, I heard the baby, and that became my sole focus.
What did you do with the child?
I got him to come to me. We went down the hallway. I remembered that it was cold outside because I had my jacket on, and there was a blanket on the back of the couch, so I wrapped him up and I went and stood on the curb with him so that he didn't have to see what was going on in it.
So whatever happened inside the room after you took him outside, you don't know?
No.
Did you ever see a Tatiana's gun?
No, ma'am. I saw her face.
Is that burned in your memory?
Yes, ma'am.
Did you ever hear the defendant say gun?
No, ma'am.
Fort Worth Police Department, lots of folks show up, right?
Yes, ma'am.
Chief of Police was up there, is that right?
Yes, ma'am.
Okay. At any point from the time that you're in the backyard and you go to the side, all the way to the front, does the defendant tell you gun?
Not to my knowledge.
She had a gun. What about as you guys run inside that house? Does he ever warn you that she has a gun?
Not that I can remember, no.
When asked to rate his actions leading up to the shooting, Dean astonishingly rated himself a B, a passing grade. Dean's own testimony revealed a pattern of dangerous police work, ultimately leading the prosecutor to expose his lack of regard for his partner's safety and the life of Jefferson.
And so right now, you've just shot at Tatiana Jefferson. Is your gun, that Glock, is that a firearm?
Yes.
Is a firearm a deadly weapon?
Yes.
When you pointed your gun at Tatiana Jefferson and pulled the trigger, did you intend for the person on the other end of that bullet to die?
I intended to stop the threat.
And stopping the threat means stopping the threat that they could die, right?
It's a possibility, yes.
And because pointing a gun and pulling the trigger, that's an act really dangerous to human life?
Yes.
If you do it to somebody else?
Yes.
So, are you still standing in front of the window at this point?
No.
If somebody was looking outside that window that we see, and we've got this paused on 1:28 seconds, I believe, someone from inside that window couldn't see out to you?
My apologies. I'm sorry. I thought you meant directly up against it.
No, but anyone inside that window, inside that house, can see you from that window, can't they?
Yes.
And if there were 10 bad guys, they could have 10 guns trained on you right now, correct?
Yes.
And you're not doing anything tactical to protect yourself at this point, are you? You're just standing there. Isn't that correct?
Yes, I believe so.
So all the bad guys that you think are in that house, they can take a free shot at you right then, and there's nothing you can do about it. Your gun's in your holster, isn't it?
No, it's in my hand.
Oh, it's in your hand. You still have your gun out.
I think so.
How come it's not trained on the window there?
It's a quickly evolving scene. We're moving around.
But the bad guys are all in that house for free to take any shots of you they want to in this position, correct?
If there were, it's possible.
Well, that's what you thought. That's what you told this jury earlier, that this was, you had determined this was a burglary in progress and there could have been lots of bad guys in the house.
I didn't have any way of knowing how many people were in there.
Okay, so we paused it at 1 minute and 37 seconds. Where are you heading at this point?
Back around to the front to go inside.
So what, in your head as an officer, what do you know that you just left in that backyard on the other side of that window?
The person that I shot.
With what?
With my gun.
Could the person, do you know for a fact that you hit the person that you shot at?
Yes.
Do you know if they're mortally wounded?
No.
Or did you know if they weren't capable of getting up and climbing out that window?
No, I didn't.
So, who's covering your 6 when you and Officer Darts are running to the front of this house?
We've had a threat. I've shot the threat. The threat's down. Now we're trying to move into the house to render aid.
You just said you didn't know if the wound was mortal.
The person was laying on the floor and not getting up.
Could they have been playing possum?
I suppose.
Did you know if there were other people, other bad guys in there with guns?
Not at that time.
So who is covering your 6, and Officer Darts' 6, when y'all turn tail and run to the front of that home?
No one.
Is that good police work?
It's the only way to do that. We had to run inside and clear the house and render emergency aid to this person. There was no one else out there.
But, see, you keep going back and forth. Were you going to the house to render emergency aid, or were you going in the house because there could have been more bad guys there?
Both.
Both. Okay. So if there could have been more bad guys there, was it a good idea to leave the back of the house without surveillance and expose you and Officer Darts' 6 as y'all ran to the front of the home?
As I've already stated, there are risks in police work, and I had to make a choice.
It wasn't a good idea, was it?
It was the only idea. It was the only way to do that.
Just like the only choice, just like you're telling the jury, the only choice you had was to shoot and kill Tatiana Jefferson.
Yes.
Did you have a choice whenever you didn't knock on that front door?
Yes.
Did you have a choice when you didn't announce Fort Worth Police?
I could have, but I would have exposed myself to a potential burglar inside.
Did you have a choice when you did not knock on the side door?
Yes.
Did you have a choice when you did not announce yourself as Fort Worth Police on the side door?
That's not what we're supposed to do.
Did you have a choice?
There's always a choice.
Did you have a choice to enter that home and open the door and see what was going on inside?
Not a safe one.
Did you have a choice whenever you could have stepped back, established a perimeter, and called for backup?
Yes.
Did you have a choice whenever you saw those cars parked in the driveway to establish that they were in fact the owners?
That would have been part of the procedure later, yes.
Did you have a choice whenever you did not call dispatch to contact the person that called police in the first place to get more information?
We weren't at that step yet.
But you had a choice, you could have done that, couldn't you?
Not without violating the general orders. We weren't at that
Which
step
one would
yet.
that have violated?
That would have been, we hadn't finished inspecting the structure yet.
I thought this situation was fluid. Was it not?
We were still investigating we were still inspecting the structure.
And you had a choice whenever you and Officer Darts walked in that backyard with with exposure to unknown buildings that were looking over the backyard. You got a choice there, correct?
I suppose we could have just stayed home, but no.
Oh, you could have just stayed home? And why do you joke about just staying home? Is that because home is supposed to be a safe place?
It's not a joke. My point is simply that
It sounded like a joke to me. Is home supposed to be a safe place?
Your Honor, we object to the badgering and allow the witness to finish the question and answer it.
Sustained.
May the witness answer the question?
Well, re-ask your question, Mr. Smith.
Is a person's home supposed to be a safe place?
it is.
You should feel, if you don't feel safe in your home, there's nowhere else you're going to feel safe. Is that correct?
I agree.
And this is Texas. There's nothing wrong with a person owning a firearm, is there?
No.
As a matter of fact, if one of your loved ones was at home alone with a child and heard something in the middle of the night, you would hope that your loved one maybe would go to their backyard window with a gun, wouldn't you?
Maybe.
To protect themselves and the child, isn't that correct?
Yes.
Especially if they saw flashlights in their backyard, isn't that correct?
Possibly.
Flashlights of a person announcing their presence in their backyard where they're not supposed to be?
Possibly.
So you had a lot of choices that night, didn't you?
Yes.
The jury, unimpressed by Dean's weak defense and the overwhelming evidence against him, convicted him of manslaughter. The prosecutor had successfully destroyed any notion that Dean's actions were reasonable or justified. Dean showed no emotion when the verdict was read, sentenced to nearly 12 years in prison. However, Jefferson's family did not feel that justice had fully been served and continued to pursue federal charges and civil lawsuits against Dean. This case stands as a stark reminder of the dangers posed by unfit officers, whose lack of judgment and professionalism can have devastating, irreversible consequences. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.
That sucks. Then write a better report. Too bad, so sad.
Statement. I smell marijuana. You look intoxicated. Because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him.
Man, perhaps, but he's in custody. He's in jail just sitting there. You know, I'm with you. Okay, be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man. Good luck.
Here are unforgettable moments when Judge saved people from evil cops. Michael Jones was standing outside a residence when officers arrived in response to a disturbance call, but as soon as they got there, he began walking away. Under Texas Penal Code Section 42.01, speech alone, even if loud or aggressive, does not constitute disorderly conduct unless it provokes an immediate breach of peace. The officers, however, commanded Jones to stop and put his hands behind his back without giving a lawful reason. When he hesitated, they accused him of resisting and used force to detain him. This was a clear violation of his rights, as walking away is not a crime. The officers were attempting to manufacture probable cause after failing to find a legitimate reason to detain him.
Good morning.
Hey.
How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay?
Stuff with me right back there. She's going to read it again, okay?
Okay. What happened?
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No. Just losing?
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know about that?
and
Yes,
aggressive
Judge,
behavior.
but
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance, somebody's asking him to leave, they're yelling and screaming at each other. Police coming up and saying, hey, I'm the police. You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated. Because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
During the hearing, the defense attorney pointed out that Jones had no legal obligation to comply when he was not being lawfully detained. According to Terry vs. Ohio, 392 U.S. 1, 1968, a police officer must have reasonable suspicion that a crime is occurring to justify a detention. The officers had no basis to stop Jones beyond an assumption of intoxication, which was unsupported by concrete evidence. The judge recognized that the situation escalated only because the officers refused to let Jones leave. If they had no valid reason to investigate him further, any subsequent resistance was irrelevant. This made the entire arrest unlawful, and the judge knew it.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
a criminal trespass.
They're called as a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So the trespass investigation ceases because he's leaving. Right. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is?
Okay.
The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to...
Yes, Your Honor. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred to determine, you know...
He's leaving.
He's walking.
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only...
Right? So it's like adding fuel to a fire.
But they still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw him refusing to leave, and he leaves. He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't be... It wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you that's all.
Thank you. Hear what happened?
After hearing both sides, the judge ruled that there was no probable cause and ordered Jones to be released. Under the exclusionary rule established in Mapp versus Ohio 367 U.S. 643 1961, evidence obtained through unlawful means must be suppressed. The officers had no legal standing to arrest Jones for interference when they lacked lawful authority to detain him in the first place. The judge even warned Jones to be careful in the future, acknowledging that bad policing can make innocent people targets. This decision protected Jones from wrongful imprisonment and sent a message against abusive police tactics. Just like this incident, here's a moment when a judge saved a man from corrupt policing.
We need to have like a workshop on how to write ORs, man. For real. Everything in this office report is conclusory, suspicious, aloysius,
A Texas man, Keon Shaw, found himself in court facing charges of fleeing a police officer, carrying a potential 6-month jail sentence and a $2,000 fine. The arrest stemmed from an officer's claim that Shaw was driving at an unsafe speed above a 35-mile-per-hour limit. However, under Texas Transportation Code, Section 5, 45.351, an unsafe speed must be determined based on specific conditions like weather, traffic, and visibility, not just a vague assertion by an officer. The police report failed to specify Shaw's actual speed, making the claim conclusory and legally weak.
Shaw. Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
The officer, he was originally traveling at an unsafe speed exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
anything illegal with that?
During the hearing, the judge quickly recognized the report's flaws. The officer's account lacked crucial details, like how much Shaw exceeded the speed limit. Under Texas Transportation Code, Section 5, 43.006, a traffic citation must specify the offense clearly, ensuring a driver understands what they are accused of. Yet, the officer's report merely labeled Shaw's actions as suspicious without legal backing. This raised concerns about racial profiling rather than legitimate law enforcement. The judge saw through the weak probable cause and refused to allow vague accusations to justify the arrest.
So
anything illegal with that?
I believe it would just be the speed limit would be the point at which the officer...
It's a conclusory statement. We need to have like a workshop on how to write ORs, man. For real. Everything in this office report is conclusory, suspicious, aloysius. Is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the
Sure.
terms.
Let's do this. I'm going to have him, because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay.
A few moments later.
Okay, come on up, Mr. Shaw. All right, so we're gonna do Shaw now since he's, yeah. All right. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm going to find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man. Good luck.
The prosecution had no additional evidence to justify the charge. Seeing this, the judge ruled there was no probable cause and dismissed the case. The judge warned Shaw to stay careful on the roads, but more importantly, he refused to let an officer's vague and conclusory claims dictate the fate of an innocent man. If the judge had not intervened, Shaw could have faced unjust prosecution based on an officer's assumptions rather than clear legal violations.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point it is.
I'll check the...
A man was charged with driving while intoxicated after an officer claimed he caused a crash. Under Texas Transportation Code, Section 550.021, a driver involved in an accident resulting in injury or damage must stop and provide information. However, the officer's report initially stated the accident occurred on US 50, but later changed it to US 59, raising serious credibility issues. The judge quickly caught this inconsistency, questioning whether the arrest was even valid. Since US 50 is not in Harris County, the officer's shifting statements suggested possible misconduct. This error cast doubt on the entire case, putting the officer's integrity in a question.
Mr. Lozano, come on up.
We were in an accident on 59. Gonna take advantage. He doesn't get prior.
Any prior DWIs?
I don't believe he's got any priors of any kind. No.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The real witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard field sobriety were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on.
Where is it?
It said US 50. That's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious? Do I need to look it up? I don't know.
Your Honor, the DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway. So they put 50, but then later in the DIMS they did put 59. So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59? Or is that 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas 77004.
Is that what really happened, or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if we
definitively point it is.
I'll check the OR and see if they clarify in the complete OR. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas 77004.
So is 50? It's not in Harris County.
He switches between 50 and 59 in the offense report, Chief.
I know probable cause.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to. He's great.
The officer claimed the driver showed signs of intoxication, listing slow speech and disorientation as evidence. Under Texas Penal Code Section 49.04, a person commits DWI if they operated the vehicle while intoxicated in a public place. The officer also conducted field sobriety tests, alleging the driver failed multiple tasks, but the driver denied drinking that day. The officer then sought a blood warrant after the driver refused a breath test, but the contradictory accident location weakened probable cause. The judge, seeing the flawed report, focused on whether the case had legal grounds to proceed. Without reliable evidence, the case appeared built on questionable claims rather than lawful procedure.
Listen to. He's great. He'll help you out whenever you need. You know. All right, man. Good luck.
Excuse, Judge. Yeah. All right, I'll meet you in the hallway. Okay.
The judge dismissed the case, and in this next case, a man was pulled over for speeding, and officers claimed they saw him trying to hide something near the center console. Based on this, they ordered him and his passenger out of the vehicle. As the passenger stepped out, the officer then claimed to have seen a plastic bag with a green leafy substance that smelled like marijuana. However, there was no clear indication in the report that the bag was directly tied to the driver. Under Florida statutes Section 893.13, mere proximity to a controlled substance is not enough to establish possession. There must be evidence that the accused knew of its presence and had control over it. The defense attorney pointed out that the passenger was the one who ran away, which made it more likely that the marijuana belonged to him rather than the driver. The report failed to specify where exactly the drugs were found or whether they were in the driver's immediate control.
What's going on?
Judge, I'm here on docket for Mr. Nathan Rhea, Judge. I'm seeing if you'll revisit probable cause in this case.
You said Rhea?
Yes, sir. R-H-E-A, Judge.
Okay. Is it on docket today?
Yes, Judge, it's my understanding.
Jail, maybe jail docket. I see, yeah, it's jail docket.
Yes,
Okay.
sir.
All right, you ready?
Yes, Judge.
Go for it.
So, on December 29th, 2024, the officer observed the defendant's vehicle traveling 91 miles per hour in a 50 mile per hour zone. A traffic stop was initiated, and the officer observed the driver leaning over the console, trying to conceal something next to the console in the front passenger seat. The driver and the passenger did not see the officer as he was standing near the driver window, where the officer observed the driver have his hand between the front seat and the center console. The officer ordered the occupants out of the vehicle and observed a plastic bag containing a green leafy substance with an odor of marijuana as the front passenger exited, and the front passenger immediately took off running, and the defendant, the driver of the vehicle, stated he only knew the passenger to be named Junior. The weight of the marijuana was 0.3915 ounces.
Judge, looking at the totality of the circumstances, the state has not been able to allege enough probable cause that my client knew or intended that there was marijuana in his possession. I understand that the allegations say that there was some type of furtive movement, but my client yielded to law enforcement show of authority, and then gave law enforcement his identification. The passenger ends up leaving law enforcement. He stays there, and again, there's not enough to establish that he knew or intended that there was weed in his car. The allegations also don't, pinpoint where the marijuana actually was. So this was unbeknownst to my client, Judge.
So he comes up, Officer comes up to the car and he sees him trying to conceal.
Yes.
Right?
I don't think that, I believe the allegations say that that's what the officer maybe seems to believe, but after further review, there's nothing that says that's definitive or that's even probable cause. For all we know, he was rummaging around to give him his ID, which he did. That's why he got picked up.
No, but he says he's got a plastic bag and he's trying to put a plastic bag behind the console.
Because, Your Honor, they found his hand between the front seat and the center console. They observed his hand in between the console.
There was a plastic bag too?
It says that they observed a plastic bag containing the green leafy substance. Yes, Your Honor. And that was after the passenger exited. So when they walked up, they saw him with his hand in between the console and the front seat where they observed him trying to conceal something.
So, Judge, in the DIMS, it says, quote, as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance. The way I'm reading that, Judge, is that's more attributable to the passenger and the alleged marijuana that was near his person than it was my client. Again, the rummaging around, Judge, I don't think there's enough of a nexus to establish that. My client yielded to law enforcement's show of authority. He gave law enforcement his ID. While he's standing there submitting to law enforcement's show of authority, the guy with his hands up with the marijuana that's around him leaves. So if anything, this should be attributable to the passenger.
Saying that the weed is the passenger's client, not your client. That's what you're saying.
Yes, and based on the allegations, Judge, there's not enough probable cause that attributes my client knew or intended that marijuana was in his possession when everything just as much points to someone who ran away from the cops.
Read the DIMS again, and then who is the one who's allegedly hiding things? Is it?
It's the driver, Your Honor, which is the defendant. Right. The officer said the officer observed the driver have his hand between the front seat and the center console, and previously...
Okay, wait. So between the front seat
in the center console, and the officer said, I observed the driver leaning over the console trying to conceal something next to the console and front seat passenger. And that's where he observed his hand in the front seat, between the front seat passenger and the console. So the officer observed him trying to conceal something. And all the DIM says in regard to the passenger and the marijuana is that as the front seat passenger exited the vehicle with his hands up, I saw a plastic bag containing a green leafy substance smelling of marijuana. It doesn't say anything in regard to it being solely in the passenger's area, because it said previously he was trying to conceal something.
Again, so my apologies, counsel. Judge, if I may.
He's actively trying to conceal a plastic bag?
Your Honor, so with this situation, when we were briefly speaking, allegedly this driver and passenger don't know each other, but then in this situation, should this person, the defendant, be pulled over for speeding, one would think he'd keep his hands 10 and 2 and not be trying to conceal something, so that's where we're at. And if you didn't know that didn't know the passenger, didn't know that they had the marijuana, didn't know anything about the marijuana, why are you concealing? Why aren't you keeping your hands at 10 and 2?
The officers claim that the driver was concealing something was used as justification for further investigation, but the judge wasn't convinced. Under Florida case law, furtive movements alone are not enough to establish probable cause unless they are combined with other clear evidence of a crime. The officer's report was vague and didn't explain exactly where the marijuana was found in relation to the driver's supposed movements. If the driver had truly been trying to hide a plastic bag, the report should have specified that officers found drugs in the same spot he was allegedly reaching for. Instead, all the report said was that they saw marijuana as the passenger exited. The judge called this out, saying it's not that hard to write in the report, I saw weed where I found his furtive movements. Without a clear link between the driver and the drugs, the state's case was weak.
Judge, anytime somebody's driving, again, I think there's a reasonable inference that goes just as much to my client was trying to go through his belongings, give law enforcement the correct identification so that he could submit to law enforcement show of authority. Again, just because it says concealed doesn't mean that there's enough allegations that actually substantiate that anything was concealed. If anything...
No, but is that enough for him to continue and to investigate further? Right. His allegation is, I come up to the car and I actively see someone trying to conceal something. So at that point, I'm going to investigate further.
My issue is not, law enforcement had the right to further investigate the case. We understand that my client was speeding, Judge. My issue, though, is that they're saying that the front seat passenger is getting out of the vehicle and then he sees weed as the front seat passenger gets out. My client is already.
So who do they both have weed? Is that what happened here? Do they both end up with?
My understanding, Judge, is that there's enough probable cause that actually goes toward the passenger being in possession of.
Did they find weed where he was trying to conceal whatever he was trying to allegedly conceal?
The allegations are not clear about that, Judge, which is why.
Admittedly, they are not clear about that because all it says is that as the front seat passenger exited, they observed the plastic bags. But previously, they did say.
Where?
It does not say, Your Honor.
That sucks. Then write a better report.
It does, but they did say that concealing something.
I need to know where is the weed in the front seat passenger?
All right, there are enough affirmative links still because he's the operator of the vehicle and is within his wingspan, and they saw the previous furtive movements being made to draw the inference of knowledge. So there's enough affirmative links between him and the contraband for a probable cause.
I don't work on hunches.
It's not a
hunches here. I mean, it's not that hard to write in the report. Well, I saw weed where I found his furtive movements. You know?
Yes, Your Honor. They didn't clarify that, but they did see him concealing.
Then, too bad, so sad. Sorry.
I will say, Your Honor, this did just happen 2 days ago. If we could wait to get the offense report, maybe he articulated it.
No, I mean, he's in custody. I don't want to wait 2 days because he's in custody. If he was on bond, perhaps, but he's in custody. He's in jail just sitting there, you know? I'm with you. Okay.
Thank you, Judge Fletcher.
Since the driver was still in custody, the judge wasn't willing to wait for a better report. Under Florida rules of criminal procedure, a person in custody must have a determination of probable cause within 48 hours, or they must be released. The judge acknowledged that if the driver were out on bond, there might be time to clarify the report, but in this case, he wasn't going to let someone sit in jail based on weak allegations. He ultimately sided with the defense, making it clear that law enforcement needed to do better if they wanted to justify keeping someone locked up. When you think you've seen it all, here's a crazy incident where cops wants to destroy someone.
Listen, you don't need to say a word. Good morning, Mr. Bayo. You speak English, right?
Yes.
Okay. Shh. All right, Mr. Bayo, you're charged initially as of, it looks like November 7th, you picked up an assault of a family member. I see now that you've picked up a new case. As of November 30th, you've picked up a violation of a bond condition or protective order. I don't know which it is. All I know is that you picked up a violation case. You're facing now another year in jail and or a $4,000 fine. I haven't done probable cause, so we're going to do that. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
The prosecution alleged that Mr. Bayo violated a protective order by going to the residence of a protected individual, Mr. McWilliams. Under Texas Penal Code, Section 25.07, a person commits an offense if they knowingly or intentionally violate a court-issued protective order. However, the defense quickly pointed out a major flaw. The so-called protected residence was not McWilliams' home. Both McWilliams and his ex-wife, Shannon, confirmed that he had moved out before the alleged violation. Without this key element, the charge had no legal ground.
Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated that he was locked out of his residence by his ex-wife's new boyfriend. Complainant went to the residence because his ex-wife had called him and stated that she was going to work. When the complainant asked who would be watching their children, the ex-wife said a friend. Complainant then heard defendant's voice in the background and went over to the apartment. Complaining witness is the same complainant.
You said he heard whose voice?
The complainant heard the defendant's voice in the background. I think that the complainant believed that the defendant would be watching his and his ex-wife's children, and that's why he went over to the apartment. Complainant is the same complainant from a pending AFM, and the apartment address where the defendant was staying is listed on a signed order of protection.
How bad of an assault were we talking in the original case? What happened?
I think it was punching in the face with a closed fist.
Once, twice, thrice?
2 to 3 times, it looks like, Judge.
Okay.
And I can give some excellent background on that I think they're also still working through.
On the assault case, we issued a protective order, I would imagine.
Yes, and I've got a copy of that, Judge, if you need to see.
Did we order him not to have contact with this person?
Yes, but that's not the basis of the new charge. And so if we delve into the state's filed information, which is also the basis of the allegation he violated, well, imagine you're hearing both kind of in conjunction, the new charge PC, but also considering the questions of bail with respect to the first charge as well.
Of course.
What's been alleged in the new information is that Mr. Bio went to the residence of the CW, Mr. McWilliams. As of the date when we first appeared in court, the representation was made by both Mr. McWilliams, and then today the representation was made by the ex-wife of Mr. McWilliams, who is the dating partner of Mr. Bio. So he is dating this gentleman's ex-wife. But she has confirmed to both of us that McWilliams has moved out of that residence as of the date of the first alleged assault. And McWilliams has told them that. They have been unable to reach McWilliams as of recently, but in the RIP call information, McWilliams confirms, I moved out that day and do not live at the address that's at issue in this VPO case. If you look at the filed information in that VPO case, it's a necessary ingredient of that allegation that McWilliams live at that address. It specifically says it in the last line.
You're saying in the protective order?
Yes, Jim. Oh, no, not the protective order. In the violation of protective order case, if you look at the state's filed information in that case, you will see the last line is, to wit, he was at the complainant's residence, but Mr. McWilliams doesn't actually live there. He moved out. Actually, was not on the lease.
He's still not supposed to have contact with this person.
Well, he's not. He didn't have contact with him. What happens is he's at a place that is not McWilliams' address, and then McWilliams, angry that he's there, still wanting to control his ex-wife, comes over there and busts the windows. And so that is
What's the window of
his ex-wife's house where Mr. Bio.
What's the ex-wife's name?
Shannon.
Okay, so
we both spoke to Shannon a few minutes ago.
And Shannon has how many kids with Mr. Bio? Or do they have kids or no? So whose kids are they? McWilliams?
McWilliams and Shannon's children.
Okay.
I think there's 2.
And so what's alleged in the newly filed charging document is that Mr. Bio went to the residence of McWilliams, which there's no PC to believe in. He did not go to the residence of McWilliams. He went to Shannon's residence. McWilliams does not live there, stopped living there, and the state can't meet the information. And so there's no PC on, my argument, Judge, is that there's no PC that the state or the officer.
So in our case, in the assault case, the protective order says that he's not supposed to go to this Spring Cypress, the apartment in Spring Cypress, right?
Well, contemplating that that's McWilliams' address.
Is that his address? Yes or no?
That is no longer his address, Judge.
Okay.
When that was filed, I imagine that was the original apartment, but on the
Because a lot of
day,
times they never update it. They just put the original apartment where it happened at, and they always assume that it's this, just.
so that's no longer the address. Mr. McWilliams moved out of that address on the day of the incident, and he told me he moved out. I believe that Shannon is the only name on the lease.
For the violation case, where is he alleged to have gone to?
He went to the address that's listed in the original MOA. So he went to the Spring
Cypress.
Right.
That's right.
Okay. But what he's saying is that this person no longer lives there.
Despite the accusations, it became clear that Mr. Bio had not even interacted with McWilliams. Texas law requires that probable cause exist for each element of a crime to proceed with charges. In this case, the prosecution's claim hinged on McWilliams still living at the apartment, which he didn't. Shannon also confirmed to both the state and defense that McWilliams had moved out, making it impossible for Bio to have violated the protective order. The judge, recognizing the lack of evidence, immediately questioned the legitimacy of the charge.
Well, that's what McWilliams told the state, and that's what Shannon has told both the state and myself, and that is what our full understanding is. Now, I know that address is listed in the protective order, but what's contemplated by the protective order is don't go to a place where McWilliams lives. And McWilliams is not living at the Springside.
The problem is that we also have this address there because he could always go back.
Well,
he may not live there. Maybe he lives there partially. Maybe he comes and goes.
Well, what else was he
is
kicked out?
Also as a preventative measure so that we don't want you to actually or accidentally bump into this person. And that's why we have this there, is that he did live there at one time. Perhaps he may go back. He left an article of clothing. He left pizza there, or whatever it may be.
Well, what's really happening is he wants to go back and continue harassing his ex-wife. And that is what Shannon has represented, I think, to both of them. I wasn't privy to their phone call. Certainly what was represented to me. And
what do you want?
Well, I want no PC to be found on the violation of protective order charge, because an element of that offense that's been alleged is that Mr. Bio went to the residence of McWilliams. McWilliams does not live there. It's not his residence. So there's no PC to believe that that element is met.
What do you think?
Judge, I don't know, on this matter.
I gotta think expressed in the order is that address was PC, but the actual information.
I will say, Judge, in the charging instrument, the defendant it does say, he's not allowed to intentionally or knowingly go to a place specifically described in the order. The address in the order, that's where he was staying. But in terms of
the address in the order, who was staying?
The defendant was staying at the address in the order.
In this
In the original Moab, Spring Cypress.
Okay.
The defendant was staying there. But I will say in terms of PC, I'm going to defer to the court on this matter.
May I just read that little blurb of the information that I think is important for the court to hear? May I take a cheat and steal y'all's computer? Go ahead. So,
do we still have a problem with him trying to communicate, though?
No, he didn't want to have any communication. This gentleman comes over to the place and starts busting the windows.
I will say the complainant came to the place where the defendant was staying. Like, he initiated the contact in the situation.
And what's alleged is, and it's the last clause, maybe two clauses, it says a place specifically described in the order, to wit, the residence of a protected individual, namely Mark, and it should say McWilliams, but it says Mark Williams. So it's in order to meet this charging document, it would have to be that gentleman's residence, and he does not reside there, as by his own representation to the state. And so I'd ask that, and I know it's a very unique situation.
How do we go forward, though? If I find no PC, how do we go forward? No.
Well, goes back out on bond while we prepare our defense to the initial charge of assault, which I think they've seen quite a bit by way of background about Mr. McWilliams.
How do we know that this isn't going to happen again?
Well,
I will say, I'm not sure where Mr. Byer will be staying if he were to get out on bond, but the witness, Shannon, she is no longer living in her apartment as of tomorrow. So that address it won't even belong to any of them as of tomorrow.
Judge Fleischer wasn't fooled by the prosecution's weak arguments. Under Texas Code of Criminal Procedure, Section 17.15, bail decisions must consider the safety of the community and the likelihood of reoffending. The judge noted that McWilliams himself had been the aggressor, breaking windows and escalating the situation. Instead of blindly siding with the state, the judge saw through the inconsistencies and ruled that there was no probable cause for the violation charge, preventing an unjust prosecution.
Do we do a no contact with both?
I don't we would do no contact with the witness, with Shannon. But I would ask no contact with Mr. McWilliams.
You are now in a relationship with Shannon, right?
That's right, Judge. Just yes. But yes, so I've instructed him, just let me answer for him, Judge. But he is in a relationship with Shannon, that's right. And he moved here from Hawaii to be with Shannon, and the ex-husband takes issue with it. And the ex-husband has a very violent history with Shannon. And so, long-term, we think there'll be issues with case 1 even. But I understand that that's not really we're not there yet. I think the question is what to do if he is out. I do think, obviously, no contact whatsoever in any form, shape at all with Mr. McWilliams is appropriate, and that is what existed. Unfortunately, the state can't even reach McWilliams because he doesn't have a phone number that is even good.
Have you run an NCIC check on this McWilliams guy?
We can see his in-county criminal history, but I can run a new check on him.
Do you see, I mean...
And I don't want to be incorrect, but I think he's got violent history with Shannon, but maybe good when you get to be my age, it's hard to remember all the details, but I think I recall that, but maybe I'm mistaken. I don't want to represent something inaccurate.
You have inherited a dangerous situation. And Mr. Bio, you need to be very careful. You know, if you are in a relationship with someone and they have another person that's in their life that's like this, you could be the bearer of bad times. So you need to be very careful. You're in a very volatile situation. So you need to be careful going forward because it really could just could go out of control. You may need to get a protective order yourself. You know, it's very possible that you may need to get a protective order. So just be careful. You're in good hands. You ever have any issues, just reach out to Brian. We can always help you out as well. I'll find no PC on the violation of a protective order, but just be careful because there are a lot of vindictive people in this life that will they'll try to make your life a living hell. And you being on bond in this case, they can do that. They can say, hey man, he's doing this to me, he's threatening me, he's doing that. And if an officer doesn't know any better and they come up and they see that you have this open assault, they may never take your word. They may never even speak to you. They'll just put you in county. So you gotta be careful. You know, you're in good hands. We'll help you out for as much as we can. Okay? Okay, so I'll find OPC on the
And I think Judge Wood,
on the violation case. And I'm not gonna revoke your bond on the original assault case, Mr. Bio, but you gotta be careful, man, you know?
and Judge, I think you should also have him give his updated address to pretrial would be appropriate as well.
Okay. And I think there's probably somehow make a notation in everywhere so that we know where Shannon lives. You don't have an address for McWilliams, so I don't know how we're going to handle
Well,
that.
I think the protective order does say any address where McWilliams does reside. So whether or not, I guess that'd be a notice question, but we know not to go anywhere where he lives.
I think the issue is whether this other person's going to now be, Okay.
You understand all that?
Do you have any questions? Just be careful. Life's too short to live either in a 6x9 box or be 6 feet under because you got other people that have just be careful. All right.
Thank you.
Good luck. Good luck, Mr. Bio.
Before closing the case, the judge issued a serious warning to Mr. Bio. Texas law recognizes that false accusations can lead to wrongful arrests, which is why courts must scrutinize evidence before issuing rulings. The judge reminded Bio that being in a relationship with Shannon put him at risk of further false claims, advising him to be cautious and even consider getting his own protective order. By refusing to let the prosecution railroad an innocent man, Judge Fleischer proved that smart judges can stop corrupt tactics before they ruin lives. Like and subscribe for more police cam stories. Watch the next recommended video click to watch now.
Am I being detained?
Yes, you are being detained.
I know what the law is.
I know the law. I'm an attorney, so I would hope I know the law.
There's audio on mine, and I'm a lawyer, and I know what the law is.
I'm a state attorney. Second. All right.
Thank you. Your tag didn't come back. Never seen that before.
I can keep recording you.
Turn it off. I'm taking jail.
For recording you, I'm sitting in my car holding my phone.
Here are satisfying moments when smart lawyers destroys corrupt cops. These cops tried to intimidate this driver, but unbeknownst to them, he's actually a lawyer.
Hey, Bob, turn that off, okay?
No, I'll keep recording, thank you. It's my right.
Don't record me. You got me?
I will look. You're a police officer on duty. I can record you. And if you come to this side of the vehicle, I can keep recording you.
Turn it off.
I can keep recording you.
Turn it off. I'm taking jail.
While driving for Uber, his passenger got detained, and the officers tried to violate his rights.
For recording you, I'm sitting in my car holding my phone.
Record me.
What is the law? What are you arresting me for? I'm sitting here in my car. I'm just recording in case anything happens. I'm surrounded by 5 police officers.
You're being a jerk.
I'm scared right now. I'm not being a jerk. I'm recording it in case anything happens.
Under the First Amendment, citizens are granted the right to record public officials, including police officers, in the course of their public duties. This right has been affirmed by various court rulings, recognizing that recording police activities is a vital form of public oversight and accountability. Any attempt to prevent this recording is a violation of constitutional rights and undermines transparency in law enforcement.
I hope we don't find something in your car, okay?
They're not searching my car.
Well, I'm going to search your car.
You're not searching my car.
Subject to roll canine this way, please.
Bring the canines. I don't care, man.
Okay.
Okay. I know my rights.
Hey, I hope so. I know what the law is.
I know the law. I'm an attorney, so I would hope I know the law.
And an Uber driver?
And here, man.
And an Uber driver.
You want my bar card?
As an attorney, he knew the Fourth Amendment protects against unreasonable searches and seizures, requiring any search to be based on probable cause and, in many cases, supported by a warrant. When the officers demanded to search his car without proper legal justification, he asserted his rights.
Guess they're bringing the canines.
The threat to use a K-9 unit without probable cause was an attempt to intimidate, showcasing a clear overreach of police authority.
Sir, can you tell me what this new law is that I'm not allowed to record?
Sorry?
He said that there's a law I'm not allowed to record the police. I just wanted to know what that new law is.
Well, you said you were an attorney, correct?
I am. I've never heard of this law that you're not allowed to record the police anymore. It must be brand new.
Okay, well, they just recently passed it, so...
Like super recently? Seems like a strange law. Man. I showed him my way bill. I really am just driving Uber for some extra money. I don't know where these people are going to and from.
Really about 80. Are these his?
You from the area?
Probably, they're not mine.
I do most of them.
I have nothing in my car. There's no drugs, there's no alcohol.
I didn't say you did.
Well, the other officer told me he's taking me to jail. Next thing I know, I'm surrounded by police.
Are you from the area here? You live here in Wilmington?
Yeah, I live here. I work at the courthouse.
Once he proved he was a lawyer, the arrogant cop changed his tone and abandoned his power-tripping behavior.
Yes.
How long have you been an Uber driver?
Mr. St. Pierre, a year and a half, 2 years maybe?
Have you been stopped a lot? It's probably why you've been stopped, because you're an Uber driver, right? Because there's a lot of history on the vehicle.
On this vehicle there's history?
Yeah.
Not that I know of.
Okay. All right. So here's your license. We're going to wait for K-9 because I don't know if he might have dumped something under the seat and you don't want us to look. So we're just going to have K-9 come out and smell. And if they do an indication, if not, then you'll be on your way, okay, sir?
Okay. I mean, if he threw something under the seat, it still has nothing to do with me. Like.
Okay, but it's in your car. I'm not saying it has anything to do with you, sir. I've never said that, did I?
No, I feel like
question.
someone's going to be under the car and you're going to say, I'm the driver, it's my vehicle, I'm responsible.
Negative, sir. I've never said that to you.
Okay.
Okay?
Can you understand my frustration? I'm just at work.
I should. I absolutely do.
All right.
Here's your registration. Just hold on a minute, okay?
Thanks, man.
All right.
The lawyer, despite being in an Uber, stood his ground against the officer's unlawful demands and misrepresentations. Here's another incident where an attorney humbled a cop.
So am I being detained? Yes, you are being detained.
In March 2016, attorney Robert and his investigator, Jess Torres, traveled to Nogales, Arizona to interview Homeland Security officers regarding a large drug case. On their way back to Phoenix, they encountered a permanent Border Patrol checkpoint. Despite not crossing into Mexico, they were subject to inspection.
So am I being detained? Yes, you are being detained for an immigration inspection. Really? 287. The Supreme Court has decided, Martinez Fuerte. Really? That everybody has to stop.
And you have probable cause to believe I'm not a U.S. citizen?
I don't have to.
U.S. citizens generally have the right to refuse to identify themselves to law enforcement officers unless there is probable cause or reasonable suspicion of a crime. However, at the border, this right is more restricted. When attorney Robert, as a passenger, was asked to identify himself. He skillfully asserted his Fifth Amendment right to refuse to answer questions, effectively humbling the officer by standing firm on his legal rights.
How are we doing today?
Good. This gentleman decided that he doesn't want to answer if he's a U.S. citizen or not, and that we don't have a problem with that.
Which one?
Me?
You?
Yes.
So you do understand the purpose of an immigration checkpoint, correct?
I sure do.
Okay.
Well, do you have reasonable suspicion that I've committed a crime?
No, I don't, but what I do have is the right to question you. According to the United States versus Martinez Fuerte, I can't keep you here until I'm satisfied that you're a United States citizen. Do you understand that?
Well, no, I haven't committed any crime. You have no probable cause.
I'm not asking you if you committed a crime. I'm asking you if you're a United States citizen.
I don't have to answer that.
Actually, you do, sir.
Really?
And I can't keep you here until I'm satisfied.
Really?
Yes. And let me tell you this right now, okay? Since you're the driver of the vehicle, what you are doing is blocking traffic.
I'll do whatever you want me to do.
Okay, so can you pull over there to second there for me?
Yeah.
Okay, thank you.
Recognizing that the attorney was steadfast in asserting his rights, the officer called his supervisor to review the situation.
Hello? I don't have to answer that question, sir.
Are you a U.S. citizen? Yeah. And how are you guys related?
I'm not going to answer your question. Do you have probable cause that I've committed a crime and done something illegal?
No, I don't.
Then I should be allowed to go on my way.
That's probable cause has nothing to do with.
Well, do you have reasonable suspicion I've committed a crime?
You don't need reasonable suspicion for immigration inspection.
Do you think you have reasonable suspicion that I'm not a U.S. citizen?
We don't need reasonable suspicion.
Okay, then why am I being detained?
Because we're conducting an immigration inspection.
Really? You have a right to ask me if I'm a U.S. citizen. I have a right to say I don't want to answer that.
That's true.
And so you have no other cause to hold me.
Well, we do have other cause because if we're still suspicious that you might be hiding the fact that you're illegal.
Really? You really think I'm illegal? You think you have reasonable suspicion?
I'm trying to determine that. That's why I'm asking you questions.
How are you going to determine that?
By asking you questions, figuring out, just basic information.
Mm-hmm.
Where were you born, sir?
I'm not going to answer that.
Okay, so the only thing you're doing right now is prolonging your stay here.
Well, you know what? The Constitution allows me not to answer questions, sir.
Yeah, you're absolutely right. I'm not going to argue. But
I'd like to know what lawful authority you have to keep me here right now. I'm being detained. I'm not being allowed to go on my way.
Right. You are being detained until we determine whether we're satisfied with our immigration inspection.
Well, do what you need to do.
I'm doing it. So I'm going to need you to step out.
Subsequently, they began to overstep their bounds and detain him, but he retaliated effectively.
I'm not answering that question, sir.
You're going to need to stay in the vehicle.
He ordered me out.
My apologies.
Do you have any weapons or anything?
I'm not going to answer that.
So you... All right, go ahead and walk over.
Am I under arrest? Am I being detained?
Yes. Being detained, you're not under arrest.
Realizing they wanted to detain him without probable cause, he threatened to file a complaint, which prompted them to release him.
Okay, and who is the officer in charge here? It's myself and... Okay, and how do I formally file a complaint?
File a complaint about what, sir? That you refuse to answer questions related to the immigration process, which this is an immigration checkpoint.
I'm going to be polite, officer. I am just asking a simple question. To whom do I file a complaint?
I can get you a complaint form that you're more than welcome to fill out and send in.
I would like that.
Okay.
Thank you very much.
You can go ahead and get back to your vehicle and I'll get you.
Thank you very much. Have a nice day. Hold on, they're getting me a complaint form.
There you are, sir.
Thank you very much.
You have a good day.
You too.
All right.
Despite the tension, he vocalized his rights clearly and respectfully. This approach ultimately allowed them to proceed without further incident, demonstrating the power of legal knowledge and respectful assertion of rights. Here's a female attorney who humbled two cops.
Never seen that before. I'm sorry?
The officers pulled over the wrong driver after unwarrantedly running her plate number, only to discover she was a state attorney.
You're good. What agency you with?
I'm the state attorney.
Okay. All right. Thank you. Your tag didn't come back. Never seen that before. I'm sorry? Yeah.
They attempted to justify their actions by claiming they received no result from running her license plate, though it was indeed registered.
We're good now.
So it was.
We ran the tag. I've never seen it before. A Florida tag. It's never come back to anything before. So that's the reason for the stop.
What was the tag run for?
I'm sorry?
What was the tag run for?
Oh, we run tags all the time, whether it's at traffic lights and that sort of stuff. That's how we figure out if, cars are stolen and that sort of thing.
When this tactic failed, they further alleged that her car's tinted windows were too dark, despite lacking a tint measurer.
Also, the windows were really dark. I don't have a tint measurer, but that's another reason for the stop.
Frustrated by their excuses, the attorney demanded their credentials, leading to the traffic stop ending quickly after Ms. Ayala informed them of her position.
Do you guys have cards on here?
Yeah, 1 second, please. Actually, this isn't my car, but I can write my name down if you'd like.
Yeah, you put my name down.
What's your employee number? 57. Ready? There you are. Have a good day.
The video sparked immediate online attention regarding police targeting. The Orlando police maintained that the running of license plates is routine practice, allowed for official business only. The attorney responded to their comments on the X platform, highlighting the incident. Here's a satisfying incident where a female cop demolished a corrupt cop.
Okay, and I'm going to ask you to turn the audio and the cameras off because it's illegal in Pennsylvania.
It's not illegal.
Yes, it is, miss.
I'm sorry. It's not illegal.
Ma'am?
In a video documenting a February 20th, 2010 incident, Sergeant Joseph Blickley and another Ben Salem police officer, summoned to the Philadelphia Gun Club during an illegal live pigeon shoot, repeatedly misrepresent the law to harass and intimidate 2 women. Unfortunately for Sergeant Blickley, one of his targets is Philadelphia attorney Marianne Bessie, who, along with her friend Valerie Tavrino, stands up to the officers with more resolve than the entire gun club membership combined.
So we would appreciate it if you would leave. You are on private property. Thank you.
Okay, do you have the audio on those cameras?
Yes.
Okay, would you mind turning the audio off?
No, I don't need to.
Okay.
Do I have to repeat what I just said?
Well, I
to
think
young
this is
lady?
public access here.
Well, you're on private property and you're past
Well, I think
that
it's
point.
public, well, I think this is
I think
public
you're past-
access.
Miss, it is a safety.
You understand you have every right to protest, but that you can't be on their property without their consent.
Okay.
You can be on public property, you can be on the roadway where it does not impede traffic, but they have the right to ask you to leave the property.
Okay.
In the video, the police officers erroneously claim that the women are trespassing on private property, when in fact, they are within public access areas. According to Pennsylvania law, specifically Title 18, Section 3503, trespassing only occurs if a person knowingly enters or remains on private property without permission. The women assert their rights to be in a public space, highlighting the officers' misuse of authority to intimidate them into leaving.
Well, there is public access along here, so it goes to, a certain point. So I think we're within that point.
You are understanding that you're creating a safety hazard here.
No, I don't think we are.
Well, I am telling you that you are.
Well, what basis do you have for that? Because I'm telling you we're not.
You're in the roadway right now creating a safety hazard.
Well, so are you.
for people to come in.
So are the police
Because you're
officers.
here, I have to be here. miss.
Well, I think we're standing by the side of the road. We were not in the road. We were always within the public access area.
Do you know exactly where your property limits are? And we'll ask them to stay outside that.
Technically, we are responsible up to the roadway.
Okay, and I'm going to ask you to turn the audio and the cameras off because it's illegal in Pennsylvania.
It's not illegal.
Yes, it is, miss.
I'm sorry. It's not illegal.
Ma'am, you can videotape me, but I'm asking you not to audio tape without my consent. Can
Okay.
you please do that?
Well, I understand what you're saying. I do.
Sergeant Blickley misinterprets the Pennsylvania wiretap law, Title 18, Section 5703, claiming that recording audio without consent is illegal. However, the law allows for audio recording in public spaces where there is no reasonable reasonable expectation of privacy. Attorney Marianne Bessie correctly states that their actions are lawful, demonstrating the officer's lack of knowledge or willful disregard of the actual legal statutes.
Okay.
I understand what you're saying.
Audio, it's just video.
Okay, there's no audio?
No.
Okay.
There is audio on mine, and I'm a lawyer, and I know what the law is.
So you know about
I'll take the
wiretap
risk. You
laws,
can
is that
take me to
correct?
court.
Is that, you know about the
I do.
wiretap laws?
Okay, well, I'm not going to get into that here. Do you have identification, please?
I don't on me, no.
You don't have an
No,
identification?
I don't have identification on me, no.
Okay, you have no idea
On me, no.
Okay, can I have your name, address,
Sure.
and birthday, please?
What do you need it for? Am I going to be arrested?
When we get a call, we need to take a police report that we get a
Okay.
call. That's all.
What do you need my ID for? Why do you need my name?
We're here on a police call. We're having contact with you, and we're going to identify you and name you on our police report. That's what we do.
Okay, well, I'd rather not give you my name.
Okay. Why would that be?
Because I don't think I'm doing anything illegal. I don't think I'm under suspicion of anything.
Okay. Well,
Why do I need my name?
You just told me that you're audio taping us, and I asked you not to do that under Pennsylvania wiretap laws.
Okay.
Okay. She told me she's not audio taping. Audio taping. I have no problem with that. I'm asking you to do the same thing.
Okay, can we get a supervisor here? Because
I am one. That's
okay,
why I'm here.
how about you? Above you?
That's not possible right now.
Okay.
Okay.
Okay, so you're gonna take me into custody because of suspicion of violation of the wiretap law?
The officers attempt to coerce the women into stopping their documentation by falsely asserting that they are violating the wiretap law. Title 18, Section 4912 of the Pennsylvania Crimes Code defines intimidation of witnesses or victims, which includes using authority to dissuade individuals from exercising their legal rights. The women's steadfast refusal to be intimidated underscores the abuse of power by the officers, who use false legal claims to exert control.
Did I ever say that? I asked for
Well,
your
you asked for my ID, so I'm under suspicion for something, and you said the wiretap law. So what? Okay. But you said the reason that you wanted my name and not hers was because of the wiretap law. And Val, please keep videotaping the people who come in.
Okay, you asked why we need your name and information. Did I ever say that I'm going to take you into custody?
Well, you said that you needed it for the wiretap law. You said you think I'm in violation of the wiretap law, so I'm assuming that you're going to do something about that. That's why you need my name.
But I never said I was taking you into custody.
Okay, well then I don't think I need to give you my name.
Every police call that we go on, we identify who we talk to, who called the police, who we're talking to, and they go in the police report.
Unless I'm under suspicion for something, I don't think I'm required to give you my name. I don't think I am. If you say I'm under suspicion for violation of the federal wiretap law or the Pennsylvania wiretap law, that's why you need my name, I'll give you my name.
I kindly asked you to stop audio taping. That's all I did.
Okay, you did.
Okay.
Yeah, and I said that I understand I'm a lawyer, well-versed in the law. I've prosecuted cases under the federal and the Pennsylvania state wiretapping law. I know that this is legal.
Okay.
So, you're telling me you don't think it is, and you want my name to fill out in your report because you think I'm violating the wiretapping law. That doesn't make sense to me, because if you think I'm in violation of a crime, wouldn't you want to take me into custody and get all my information?
I never said that.
Okay, well then I'm not in violation of a crime?
I asked you to stop audio taping.
Right.
I said in Pennsylvania we have wiretapping laws. It's not legal to audio tape someone without their consent. You refused. I asked you for your information. I never said anything about taking you into custody.
Okay. Well, I don't think I'm violating. This is public property. This is public access.
Well, I don't know that you're on public property right now.
Well, I know that we are. I looked into it. We've done this before. We've been here many, many weeks. We stand in the public access area.
Okay.
So.
Okay. Do you know for a fact that right now you're on public property?
Well, because we stood. Now I think we're in the driveway because we're talking to you. But where we were standing.
If you're not sure either, how could you say that we're in violation?
I don't know. I do not.
Right.
If no one knows, then somebody needs to find out, and it probably would be more of your responsibility being here in the law.
Okay, here's what we're going to do.
Okay.
We cannot have you stand in the driveway here.
Okay.
On this side of State Road where this is plowed, because they've maintained it and they don't want you on the driveway.
Okay.
If you want to stand on the other side of these snowbanks, you can do that. Okay? We're going to find out through the township exactly where their property line is, but for right now we're going to ask you not to impede their traffic and not to stand in this driveway. If you want to stand on the other side of State Road, I can't tell you to stand on someone's private property. If you want to stand anywhere that's public property, you can do that. We don't know exactly how far their private property goes to State Road or what's considered public access because there is no sidewalk here under the snow. But what they're asking is you don't stand on this plowed driveway and you stand on the other side of these snowbanks.
Okay.
Meaning what would that be?
Okay.
Okay, let me finish. What will happen if we don't move?
If this is private property and you don't move, you could be cited for trespassing.
I'm asking you, what will happen now today if we don't move right now?
If you don't move
before you find out what.
Yeah, like right now you're taking his word for it and maintain, and your understanding of law is that because they maintain this driveway, we have to go, a certain distance from the snow. I'm asking you, what will you do if we don't move?
I will go to the township. I will find out exactly where their legal property line is, and if law enforcement action has to be taken or citations have to be issued, that'll be done. What the question is right now.
The video highlights the selective enforcement of laws by the Ben Salim police, who respond swiftly to the gun club's call but ignore serious allegations against its members. This selective response showcases the officer's bias and failure to uphold the law impartially.
Officer, while you're here, we got somebody on videotape who almost sideswiped me deliberately. He actually went into the snow trying to hit me when I was off the road. Well, I'll have to look at the video to see what I captured, because I won't make a report unless I actually got his information.
All right. I can assure you no one has given these people any reason to be unsafe. We would not do something like that.
Well, videotape doesn't lie.
We are being as courteous to you as we possibly can.
Video doesn't lie, so we'll see.
Yeah, it does.
Oh, it does? Okay.
The police officer's actions constitute harassment as they persistently misrepresent legal boundaries. This incident starkly reveals how some police officers misuse their authority to intimidate and suppress lawful actions, underscoring the need for accountability and adherence to the law. Like and subscribe for more videos like this. Watch the next recommended video. Click to watch now.
Step out of the vehicle. They're trying to open my door. Ma'am. Why you get?
Tell us step out the vehicle. Step out.
Mike, they're
Step out of the vehicle now. Get out now. Get out of the vehicle. Get out of the vehicle now. You're under arrest. We'll have court in court.
Yeah, we're gonna do that.
Your car is getting towed. Oh yeah, because lawyers are crooked.
I'm so glad.
Police Chief Samuel Dobbins has been fired.
As attorney Jill Collin Jefferson drove through Lexington, Mississippi, she noticed a traffic stop and began recording. One of the cops saw her drive by twice while filming and signaled his partner to stop her.
I talked to him. I'm talking to him. Well, let me say this. First. You have the right to remain silent. Anything you say can and you will be used against you in the court of law. You have a right to an attorney. If you can't afford one will be appointed for you if you wish. You have the right not to answer questions, okay? Until you have a lawyer. Is there any more weed in this car? Huh? I can't hear you. Hey, what's up? Driver's license?
Why are you stopping me?
Why are you filming me? I'm stopping you because I'm going to check your registration because you've got a tag on here that's not proper.
Actually, my tag is proper. In Mississippi, there's a certain amount of time when you have a tag.
Oh, you live that? Well, I don't know that till I stop you and talk to you. Let me see your driver's license, please, ma'am.
What's your name, officer?
Scott Walters.
My name is attorney Jill Collin Jefferson.
We know who you are.
I have a lawsuit right now against y'all, so thank you for giving me evidence.
I'm requesting your driver's license. You're driving on a public roadway. If you're a lawyer, you know that.
Why are you asking for my driver's license?
Because I'm checking your tag. Ma'am?
What's the reason for this roadblock?
It's not a roadblock. We're on a felony traffic
then
stop.
why are you stopping me if it's not a roadblock?
Because you keep riding by, and I don't know if you're trying to shoot me or hurt me. I have no clue.
Is it a crime to drive by?
I don't know you.
Is it a crime
I don't
to drive
know you.
by?
Let me see your driver's license, ma'am. If you do not let me see your driver's license.
Under Mississippi Code, Section 63-1-43, a person is only required to present a driver's license upon lawful request by an officer. However, Officer Scott Walters pulled her over without a valid reason, claiming he needed to check her registration. When she questioned the legality of the stop, Walters refused to provide a reason, instead demanding her license. Jefferson, knowing her rights, refused and called her attorney, signaling that she was prepared to challenge the officer's actions.
You can be charged. Let me see your license.
I want you to charge me. Let's do it. I'm calling my attorney right now.
Hey, I'm gonna set this car around.
You're an attorney. Wait a minute. You're calling your attorney, but you're an attorney. Not complying. I've asked for a license 3 times. Ask it one more time. Let me see your driver's license, ma'am, right now.
Why are you pulling me over if this is not a roadblock?
Ma'am, you're about to go to jail.
Hey, Mike, I'm in Lexington. The cops are saying they're about to arrest me.
For failure to comply.
Because I was driving and they pulled me over.
Let me see your driver's license.
Yeah, they're saying they're about to arrest me for failure to comply.
Because you will not hand me your license.
They stopped me when I was driving down the road, but they said it's not a roadblock. but they're trying to get my license and they're not telling me why they're getting my license.
I don't have to until I identify you.
Tell me.
As Jefferson argued with the officers, she called another attorney for legal backup. Under the Sixth Amendment, every individual has the right to legal counsel, even if they themselves are an attorney. Despite this, the officers ignored her concerns and escalated the situation. They falsely claimed she was failing to comply, a tactic often used to justify unlawful arrests. Jefferson's decision to call her a attorney highlighted the importance of having legal support when dealing with corrupt law enforcement, as officers often rely on intimidation tactics to suppress resistance.
Why you get?
Tell us step out the vehicle. Step out.
You're under arrest.
Mike,
Step out of the vehicle now. Step out of the vehicle.
They're trying
Step
to
out the
open my
vehicle,
door.
ma'am.
I'm about to roll it down. I just got hang on.
Mike,
Ma'am, you're fixing to be removed from the vehicle.
Step out
If
the
you do
vehicle.
not, I'm gonna give you the
Everything is being recorded. Everything is recorded. Step out.
Yeah, it is being recorded.
Step out the vehicle.
Okay, Mike.
Step out of the vehicle
I'm
now.
not stepping out of the vehicle.
You're gonna be charged with resisting arrest.
Oh,
Step out the vehicle.
Step out of the vehicle. I'm gonna
Step
remove
out of
you
the
from
vehicle.
Get out
just
now.
scratched my
Get out of
license.
the
Step out of the vehicle.
Get out of
You're
the
under
vehicle
arrest.
now.
You're under arrest. Step out the vehicle.
Oh, really?
Oh, she gonna resist? Step out the vehicle. Step out the
Really,
vehicle.
AG?
Step out the vehicle. Turn around.
Okay, AG.
Turn around.
Let's do this. Mike, I need you to come to... Mike, I need you to come to Lexington right now.
Ma'am, if you push me one more time, I'm gonna charge you with assault on a police officer, which is a felony.
Put you in court. What is your name? What is your name? What is your name? Huh? AG, I know you. What's your name? What's your name? Because we are about to get you. This is your last day.
You've been doing it 35 years.
Yeah, this is your last day.
Come on.
Yeah. Now, where's my license? Where am I? You know you're not supposed to do this, and you know you're about to get in court for this.
You have to listen to what the officer
You know you're about to get in court for this, right?
You have to do what the
You know
officer
you're about to be in court for this, right?
You have to do what the officer
I just want
tells
you
you to
know
do.
you're about to be in court.
Hey, that's what
You
we
need to know
that's
that.
what we
What
do.
is your name? What is his name?
That's Scott Walters.
Scott Walters. Okay.
Dash 9. Have a seat.
Scott Walters.
Have a seat in the vehicle.
Why are you trying to get me to have a seat?
Please, have a seat in the vehicle.
AG, I want you to know this is an illegal stop and this is a false seizure right now.
Okay.
I'm about to get y'all's asses. This
Okay.
is perfect evidence.
Okay. Have a seat in the vehicle.
Yeah, we got this.
Have a seat in the vehicle now.
Yeah.
Answering their 21, so it's all going to be public.
Ma'am, please have a seat in the vehicle.
I am sitting.
Legs in the vehicle.
Oh, are you about to close the door?
Have a seat in the vehicle.
AG, I'm sitting like this and I'm gonna stay like this, okay?
So we gotta put your legs in the vehicle.
So AG, if you're gonna use force on me,
I ain't gonna use force on you. You gonna put your legs in the vehicle.
what is the charge?
Please,
to comply.
please put your legs in the
There
vehicle.
is only failure to
Please
comply
put your
when I'm in the process of committing a crime, actually.
You're a lawyer,
It's
man. Correct.
I'm telling you, it's only failure to
Please put your
comply.
legs in the vehicle.
It is only failure to comply when I'm committing
No,
a
ma'am.
crime.
Not here. It's not. Put your feet in the car.
That is exactly what the law says.
No, ma'am.
Put your legs in the
Okay,
vehicle.
you know
We'll have court in court.
Yeah, we're gonna do that.
Ignoring Jefferson's legal arguments, the officers forced her out of the vehicle and arrested her. Under the Fourth Amendment, a warrantless search and seizure must be supported by probable cause. However, Officer Walters and his colleagues unlawfully opened her car, searched it, and even mocked her. During the unlawful search of Jefferson's vehicle, officers found a firearm under the driver's seat. They were happy they found evidence to indict her, but it was legally registered in her name. The gun was not reported stolen, meaning there was no legal basis for further action against her regarding the weapon. As they shut the police car door, Walters made a disturbing hand gesture, mimicking a gunshot toward Jefferson, further exposing their misconduct. This blatant abuse of power was recorded, providing irrefutable evidence of the department's corruption.
What's her problem? She thinks she knows it all.
My camera went off for some reason. It's still off. still here with your camera on?
Yeah. No, my camera never went off downtown. She was doing suspicious behavior.
You need to turn around. If the road's blocked, it's probably safe to say. You won't.
No, you good. You good.
We're just in the middle of two things.
You good. You good.
Mine went off for some reason.
Mine never went off.
So yours was recorded?
Yeah.
Okay.
That was suspicious behavior. Still riding by.
And kept riding by. And then she's got a Mississippi DL, so she's going to have 2 state IDs. Make sure there's no valuables in the car. That's what I'm looking for. You follow me?
You had reasonable suspicion anyway.
Yeah, she was acting, I was worried about my safety.
They back, man. They back. You hear me? Officers back.
Yeah, I got a lot going on here, so be sure I reply back to you before you know something.
You think I'm taking possession of her wallet?
Yeah.
Oh, man, she had, hold on. Oh, who's Timothy? She's an attorney? She said,
I guess so.
If she's an attorney, why don't she say she had an attorney? Now, if you've got a Mississippi, you can't have a Mississippi DL in another state. Oh, it expires in 17. I see. All right. So I'm going to put her wallet. That's all.
The license expired?
This is, but she gave me I've got another one. Where'd I put it at? Oh, you got it. Oh, okay, it's going to be over here. Are you shit? Number one, search engine to arrest. I'm required because your car is getting towed. Oh, yeah.
Oh, my car. Okay.
Sweetheart, we'll see. Yeah, it is. So I'm responsible in case something in there could get stolen because lawyers are crooked.
I'm so glad.
I believe it, sir.
I'm about to get a bond. Oh, is that a gun?
Oh. Please be stolen. Oh, shit, we got a gun on the receipt, everything else. It ain't illegal unless it's stolen, and please, I ain't never hoped the gun would be stolen before right now. And that's on camera. I don't
want to put you in court for sure.
I don't give a damn. Well, I've been going to court for 35 years. It won't scare me.
Yeah, I was just about to say, you found a gun. I want to get some dope in here. Just end up under the seat up under there.
I'm being allowed to 210 to the state.
I don't give a damn if you see a seed on the motherfucking floor. She must don't know the law.
She don't. That's what I'm trying to tell her.
All you need is get yours.
Jefferson refused to be silenced and took legal action against the Lexington Police Department. Under 42 U.S. Code, Section 1983, individuals can sue government officials for violating their constitutional rights. During the case, an officer falsely testified that Jefferson had blocked traffic, but video evidence contradicted his claim. Despite this, before Jefferson's arrest, an officer testified that he overheard colleagues plotting ways to arrest her.
My name is Attorney Jill Collins Jefferson.
We know who you are.
My name is Attorney Jill Collins Jefferson.
We know who you are.
30-year-old Judge Marcus Pfizer, who was not even a licensed attorney, found her guilty on all charges. Instead of backing down, Jefferson intensified her legal battle, determined to expose the corruption within the department.
Jefferson says the police department there in Lexington has been terrorizing citizens up there for far too long, and she and other leaders are calling for the Department of Justice to open a patterns and practice investigation against LPD.
Jefferson's relentless pursuit of justice, alongside the ACLU, drew national attention to Lexington's police corruption. As a result, the Department of Justice launched a federal investigation into the department's misconduct, uncovering patterns of unlawful stops, excessive force, and racial bias.
Civil rights investigation is officially underway for the city of Lexington, Mississippi, and the Lexington Police Department. As 12 News' Cameron Smith reports, officials say this investigation will determine if the behavior in Lexington violates the Constitution and federal law.
This pressure led to the firing of multiple police chiefs, including Samuel Dobbins, who was caught on tape bragging about killing 13 people. The exposure of Lexington's corruption also highlighted the need for federal oversight. with the DOJ considering a consent decree to monitor the department.
No city, no town, no law enforcement agency is too big or too small to evade our enforcement of the constitutional rights every American enjoys. Small and mid-sized police departments cannot and must not be allowed to violate people's civil rights with impunity.
Jefferson's legal battle proved that even in small towns, no police force is above the law. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.
This officer violating my rights? No, I'm not. Yes, he is.
You're talking to lawyers right now.
But you're talking to us.
Because I want you to fucking leave.
So just understand, if you come back on the property, you're going to jail.
You gonna violate my rights?
I'm gonna take you to jail.
You gonna violate my rights?
I'm gonna take you to jail, I promise.
The interaction began when officers approached a campsite in a national forest without any visible indication of illegal activity, prompting questions about their authority. Under Terry v. Ohio, law enforcement must have reasonable suspicion of criminal conduct to justify investigatory stops or questioning. The attorney immediately identified the officer's lack of reasonable suspicion and asserted his right to be left undisturbed. Their claim of unrestricted authority to interact with individuals in the area conflicted with constitutional protections against unwarranted interference.
He's on training.
He's on training?
Yeah, he doesn't, he thinks he's just trying to talk to everybody.
I know.
Okay?
And I'm trying not to talk to anybody.
Okay.
Because it's my right.
Yeah, it is.
And you guys don't have the right to come up to people that aren't obviously hunting.
Yep.
But I get it. I don't want to start an argument with you. He's a rookie. Okay. You have no reasonable suspicion to come up to me.
I'm
an attorney.
You're in a national forest. We can come talk to you.
No, you can't. I'm an attorney. What's your name and badge number?
Officer Podol,
Thank
328.
you. We're not hunting. We're about to leave. Have a nice day.
But we can talk to, we can come on.
And I can ignore you, just like I did, right?
But you're not ignoring us.
I ignored him, right?
Kind of.
Okay. I could play the game too.
I'm just no reason to get all.
Actually, there is. There's cops standing in front of me at 7 a.m. for no reason.
You're in national forest.
You're fishing game.
We're a state certified peace officer.
Guess what? You also are on my land.
It's my land too.
So I have the right to be offended that you're standing here asking me questions with no reason. Does it look like I'm hunting?
I was just asking a question.
That's what I'm saying.
I mean, we can walk around your camp with no issues. You're on forest.
You can get sued too.
I can't go into your stuff, but I can walk.
That's what I'm saying. But you can't. But not without reasonable suspicion. You can't just pull up to my camp and walk around.
Yeah.
No, you can't.
It's forest.
Do you have reasonable suspicion to believe I'm hunting? You could. No, I'll agree. I'll agree that you could do that if I'm hunting. If you see mountain bikes, okay, you can't. If you see hunting, you can. You do not have unchecked power to just walk into people's camps at any time.
Yeah, we do.
Not in the national forest.
Yes,
on state land, you do, dude. All right, so now I'm gonna have to turn this into you're gonna be on my YouTube.
Have a great day.
You're gonna get a bunch of calls.
Good.
I'm gonna make a formal complaint against you.
Yeah.
And what was your badge number?
I'm Officer Riley, badge 451. We're just trying to be cordial. That's all we're trying to do here.
Coming up to people and telling them how you think you can go places and do things isn't cordial.
We didn't walk around your stuff.
But you said you could.
We could.
And you have a badge and a gun, right? So that's intimidating in and of itself, right? So if you're trying to intimidate me, it's not going to work.
Why?
Telling me that I said I'm not comfortable with you coming up to me, and you said, well, I can walk around your camp if I want. So how is that cordial?
Because you started out with an attitude.
I started out by ignoring you, right? Hoping you'd turn around and leave, right? Because you should pick up on the hint that unless you have reasonable suspicion, we have no reason to talk to you, right? You're talking to lawyers right now.
But you're talking to us.
Because I want you to fucking leave, and I want to make a YouTube video clowning you now.
Okay.
So that's what I'm doing.
Okay. Thank you. Have a great day.
Thank you. You still didn't say your badge number either.
Yeah, I said 328.
328.
Yeah,
all right.
Watch your video.
Who's your supervisor?
Paul Greer.
So you're telling me when I take Paul Greer, he's going to tell me that you guys could. As a matter of fact, I don't even need to. You show me the ARS that authorizes you to walk through people's camps.
Show me the ARS that says you can't.
Yeah, it's called.
There has to be a law that says you can't do something.
It's called reasonable articulable suspicion.
If there's
probable
not
cause.
a law, you can do it.
The attorney shifted focus to holding the officers accountable by questioning the legal foundation for their claims. Colander versus Lawson establishes that vague or arbitrary enforcement without clear statutory authority violates due process. When pressed for the specific law permitting their actions, the officers could not provide 1. undermining their credibility. This lack of clarity exposed the encounter as an overreach rather than a legitimate exercise of authority. The attorney's insistence on adherence to the law underscored the importance of challenging such actions to prevent abuses of power.
There has to be a law that says you can't do something.
It's called reasonable articulable suspicion,
if there's
probable
not a
cause.
law, you can do it. Tell me what.
So you can make up laws. No, you're saying
not making up.
No, what you're saying, but hear me out now.
Okay, you wanted me to leave, so I'm leaving.
You're saying you can walk into somebody's camp without reasonable suspicion, right?
The attorney attempted to trap him with a question about inventing laws, but he avoided answering it. Talking about making up laws, here are cops who tried to bend the law to their own will.
This officer violating my rights?
No, I'm not.
Yes, he is.
Okay, hang on.
The officers received a call about a suspicious person and approached a man near a sheriff's office to investigate. Texas law allows officers to detain someone temporarily if they have reasonable suspicion of criminal activity. However, the man was standing on public property, which is not inherently suspicious. When the officers demanded answers, he remained calm, refused to answer questions, and reminded them of his rights. The interaction escalated when they attempted to search him, violating his Fourth Amendment rights, which protect against unreasonable searches and seizures.
Stop right there.
Back off. Back off.
No, I'm not going to back off. Okay? What's going on? What's going on? Nobody's done anything to you yet. Are you going to talk to me? Look, we got a complaint about you being up here. Talk to me.
What's going on?
Big hands out of your pocket.
Hey, you talk to me.
Don't approach me. Don't approach me. Don't approach me.
Put your hands up on the car.
I haven't broken the law, exercising my rights in public. You have no right to touch me.
Okay, what's going on?
You down quick.
This officer violating my rights?
No, I'm not.
Yes, he is.
Okay, hang on. Hang on. Hang on.
I don't consent to search and seizure of my property.
We're not searching you. We're patting you down for our safety,
Get off me,
okay?
bro. Move. Move, man. Get off of me. Stop touching me. Stop touching me. I already told you that. Sir, you have no right to touch me.
Okay, calm down.
Yes, I do.
Calm
This
down.
guy's touching me right here.
What is your name? What's going on
What's
with
your
you?
name and badge number, ma'am? Identify yourself since you want to go hands on.
I'm Sergeant Wild. What is your name?
What's your name and badge number, ma'am?
I'm asking you a question.
What's your name and badge number? Are you not going to identify yourself?
I am. You need to identify
E-hands?
yourself.
What's your badge number, E-hands? Okay, be respectful.
What is your name? You got an ID on you?
Am I being detained for a crime?
We're investigating. We got called on you, okay?
How about you guys disperse and get up out of here?
Okay.
Why would we do that?
Because you have no reason to be here.
Yes, we do.
Yes, we do. We got a call on you.
Around the sheriff's office here. Okay? We got a complaint to find out what's going on. I come up to talk to you and you take off running. So yes, that's very suspicious.
Not illegal.
I didn't say it was illegal. I said it was suspicious. I try to talk to you and you don't talk to me. So tell me what's going on.
Right now, what I need you to do is get from behind me and go back into your vehicle.
I don't have to do that.
Well, I'm gonna go and walk away then.
Then walk away. How about that? Walk away.
How about that? Huh?
Go on.
I don't have to.
Go on.
I actually can stay here if I want.
You're actually in the roadway, so.
Because you put me against the car.
Oh, no, we didn't.
yes,
You stepped over here towards me.
He did
So
not
get
move
out
me.
of the-
He didn't move me.
Okay, how about you get out of the roadway
I'll
and get
out
on the
roadway.
sidewalk?
I'll definitely get out the roadway. Not an issue there. But y'all pushed me against the car.
Okay, keep moving.
I don't have to keep moving. I haven't broken the law.
Do what?
I haven't broken the law. Ma'am, do yourself a favor. Go back in your patrol car.
You're not telling me what to do.
I am telling you what to do.
Yeah.
Well, good thing we don't have to listen to you, right?
I mean, you're wasting tax dollars, so.
On you. You're right.
That's your fault. You chose to be here.
No, we didn't.
We didn't. We got called.
I was
on you
minding
because
my own-
somebody thought it was very suspicious that you were hanging around the sheriff's office over here.
Which is funded by our tax dollars, right?
Oh, do you pay taxes?
Oh, I sure do. I pay a lot more than you think, too.
Oh, I'm sure.
I pay a lot more taxes than you think.
I'm sure you do.
E-hands, do yourself a favor. Go back in your car
You're not going to tell me when I can leave and when I can't leave.
Actually, I'm going to tell you when you
Well,
can
guess
leave.
what? I don't have to listen to you.
Well, I guess we're going to be here all day then, huh? I got nothing but. I don't care either.
Are you intoxicated? You sound like you're intoxicated or
are you making false
substances.
Are you making false
I'm
accusations?
asking you.
Are you making false allegations?
I'm asking you. Are you answering or not?
Nothing wrong with exercising your First Amendment rights in public. You guys came to me, bro.
What's the First Amendment?
Freedom of press.
Okay, what are you?
Right now, I'm recording you guys.
And for?
That's good. We're recording you too.
Because you guys are funded by tax dollars.
You're right.
Right, and we're doing our job.
Well, how about, since there's no crime happening here, how about you guys disperse?
Well, that's what we're trying to figure out.
Well, I've already explained it to you.
We got called on you. You don't need to explain nothing to us.
Don't you want to explain? You're stupid. Get out of my sight now.
For what?
Well, I can't do nothing to you because I'll go to jail, so get out.
Exactly.
Yeah, because you got that badge.
That's right.
You got that badge. That badge is the only thing that's making you stand here right now. That's
right.
That badge.
I got called here, and I'm doing my job.
Now that there's no crime committed, how about get going?
I don't know if there's a crime committed because you will not identify yourself.
I don't have to give my ID to you.
Well, okay. So what is the deal? I asked you if you were intoxicated, and you didn't give me an answer.
I don't answer questions. How about that?
Oh, okay. How about that?
Yep. Well, I got nothing but time.
The officers insisted on identifying the man, citing their need to ensure he wasn't a threat. Under Texas Penal Code, Section 38.02, a person is only required to identify themselves if they are lawfully arrested. The man, standing firm, reminded the officer that he wasn't breaking any laws and therefore had no obligation to comply. His refusal frustrated the officers, who accused him of obstruction, though he was simply exercising his First Amendment right to film in a public space.
You guys can disperse at any time you guys want. You guys can disperse at any time you want. What's your name and badge number?
It's written right there.
Written right there? Mm-hmm. Your name is right here?
Yep.
Can you pronounce it?
Born Dam.
Badge number?
222.
Good job. You already identified yourself.
Yeah, I did.
Next time when I ask you for your identification,
Okay, so first of all,
what happened? When I ask you for ID, you give it to me, okay?
you don't have to.
How about you quit running your head? Do yourself a favor.
You're funded by tax dollars. It's your obligation to identify yourself. How do I know you're not in person? How do you know you're not fake police officers?
If you think we're impersonating, call the police.
Isn't it?
They'll tell you whether or not we are, right? Good. Yeah,
that's the whole
for that one, were you?
That's the whole point of identifying yourself. That was a good. You got me there. I can't lie. I guess we're just gonna sit here and do nothing, or what?
No, we're waiting on an answer.
Answer?
Yep, from the sheriff's office. Once we get an answer from the sheriff's office, we're gonna go from there.
I just want to let you know something. You can't trespass from the sheriff's department. It is public property. Funded by tax dollars.
Actually, it's not public property.
Who funds the sheriff's department?
This isn't the sheriff's
It doesn't matter who
This is
funds
operations.
it. It's still
It's
private
still-
property.
It's in Russ, Texas.
Why does it
It's
say
like a
sheriff's
school, it's
department?
not public property either.
It's still funded by tax dollars. I could be at the prison and it wouldn't matter. It's funded by our tax dollars. So am I being detained for a
Said you were in prison? What did you
I
say?
said it's like being on a prison property. It's still funded by tax dollars.
Yeah, that doesn't mean you can't be on prison property. Try it and see what happens. Try to get in there.
I've done a lot of things on a prison
Oh, I'm
property.
sure.
before. I've exercised my rights on a prison property.
Oh, I'm sure you have.
So, I don't
Absolutely.
know what, okay, I don't know what you're insinuating, but am I being detained for a crime?
I told you you could leave, so leave.
Okay. So I'm not detained. So
I
you
never
don't.
said you were detained.
Okay, I just want to get that clarified. If I'm not detained, then I'm free to stay. I just want
No, if we're waiting on an answer to see if they want you criminally trespassed. If we do, then you're going to be criminally trespassed, and then you will leave the property. If not, you can stay here.
I am.
By all means. You can stand right there too. I don't care where you stand.
So
but if they want you CT, it's not going to be here.
Oh, I'm gonna tell you something. I'm not detained, so you don't get my ID. The best thing you guys can do for yourself is to go back in your car and leave.
Okay.
I'm just being honest.
Well, I'm glad you think that. I don't know what you think.
See, I'm so glad I do these audits.
Yeah, you're doing good.
I'm doing a very good job. Hey, you're gonna be the star of the show.
Thank you.
Yeah.
I appreciate it. That's a compliment. I like being a star.
Yeah, you say that now.
Star a lot of things.
I guess. Your attitude's a problem, man. That's
So
why.
is yours.
That's why there's a disconnect.
Yeah, I agree.
Yeah. So, that's what I'm here for, to test out, to see if you guys respect my rights, and you failed miserably.
Thank you.
You know, the other
You can
police.
put it on my eval.
The other police.
Or you can look up the complaint form and write a complaint too.
I might do that.
Do it.
I might. Just not today. I got better things to do.
Me too.
So, I mean, you can leave.
I will whenever I get an answer.
As the standoff continued, the officers warned the man that he could be criminally trespassed from the sheriff's office property. According to Penal Code Section 30.05, criminal trespass occurs only when a person knowingly enters or remains on property after receiving explicit notice to depart. The man countered that standing on public property funded by taxpayers didn't qualify as trespass. He also demanded confirmation of this claim from a higher authority, highlighting the officer's lack of understanding of public access laws.
Would respect the Constitution.
That doesn't have anything to do with you being criminal trespass.
It has a lot to do with it. If I'm not able to exercise my rights on a sheriff's department property, which is funded by our tax dollars, then that is going against the Constitution.
Let me explain something to you, okay?
Yeah.
Because who it's funded by doesn't have anything to do with it. It's like school property. School property is private property. If they want you removed from that
Depending on the schools.
No, public school is private property. It's owned by the school district, okay? And if they want you removed from that, you can be removed from that property, okay? Just like the sheriff's office. Okay? It's not public property. Public property would be like this sidewalk right here.
Which I'm not on there.
When I drove up, you were in their parking lot up there by the office, okay? So
and I was never told. I was never told to leave either.
You didn't give us a chance either. You took off running.
I wasn't detained at the time either.
No, but we've gotten to that point now where we're talking to you about it. So once we find out, then we'll go through it.
All right.
Once you criminally trespass, then we'll do that.
So you guys, man. So if I'm not detained, I'm gonna be here. I'm gonna go ahead and leave. Okay. Okay. I'm just waiting on you guys to disperse.
We're not going to. We're staying here until we get an answer.
Okay.
And we don't have to leave either. You don't have to tell us to disperse because we don't have to. We can do however we want to go.
I guess.
Yeah.
I guess. Okay. I would like to have the sheriff come out here to confirm your criminal trespass too. Well, I'm not gonna take your word for it.
You don't have to.
I'm not gonna take your word for it, man. I would rather have the sheriff tell me. So I have that right. I have that right.
If they tell us to do that, then we'll do it. That's our legal right.
Well, we'll see. You seem kind of bored.
I am.
You know,
I'd rather be doing with real crime instead of making people like this.
Well, you can leave.
Who think they know the law.
I do know the law.
Oh, I'm sure you
I may not know all the laws. That I'll give you.
agree with that.
That I'll give you. But I know enough.
All right, Sheriff said you need to leave the property.
I am on the sidewalk.
Okay, then keep walking.
I am on the sidewalk. This is not their property. How about you disperse, and when you guys leave, I'll leave.
How about you quit running your dumb mouth?
Why you gotta be so mean?
I'm not mean. You're just making a fool out of yourself.
You're calling me dumb.
So let's get something. I want you to understand something, okay?
Yep.
If you go back on the property over here, the sheriff's office property, that's the parking lot, their property, anywhere around there, okay? And we come back and see you there, you'll be arrested and you'll go to jail, okay? So don't do that. Sidewalk's okay.
I mean, if you want a lawsuit, go ahead.
It's not about whether we want a lawsuit or
I'm
not.
just saying,
It's about you're being criminally trespassed from that
from a public facility, man. It's not a public facility. So what if I need
So can you walk in there right now?
Right now it's closed.
Exactly.
That don't mean
that means it's not open to the public right now. So
it is a public facility.
No, it's private property. Belongs to the county. That makes it private property.
Nah.
Yes, it does.
Who funds the county?
It doesn't matter who pays for it.
I pay taxes, so therefore I fund the county.
It has nothing to do with whether it's private property or not. That's what I'm trying to explain to you about the school, Walmart, all these where you go shopping. All these places are private property.
The school is funded by public, but I have no reason to be at a school. I don't test teacher about their rights. I test police about their rights.
Yeah.
That's all I do, man. And if you know I'm not breaking the law, why not just?
Okay, you were on private property. They wanted you to leave. You were suspicious. We came to check you out. You took off running. That's even more suspicious. Instead of just stopping and talking to me like I wanted you to, you decided to make this a bigger deal than what it is.
There's nothing wrong with exercising your rights in public. We all have our styles of doing it.
There's nothing wrong with me doing my job either, right?
I mean, there's a way about going about doing your job.
There is.
You're threatening to arrest me for going back on the sheriff's department.
To arrest you.
You just said if I go on their property that I'll be arrested.
Yes, because you are being criminally trespassed from that property.
Which is funded by tax dollars.
Want you there.
Well, how about get the sheriff out here?
I don't have to get anybody out here.
Or a deputy sheriff.
I don't have to have a deputy out here. They told us we have the authority to do it, okay? It's within the city limits. Okay?
Whatever you say.
So I'm just letting you know, don't go back on the property, okay?
Okay. Do you just want to go home now? I mean, do you want to go back on patrol? Clearly there's no crime happening. Clearly there's no crime happening. Right now.
I'm sure there is elsewhere.
Well, maybe go.
That you have us tied up with. So just understand, if you come back on the property, you're going to jail.
You're gonna violate my rights?
I'm gonna take you to jail.
You're gonna violate my rights?
I'm gonna take you to jail. I promise you that.
That's how we gonna do it. Okay. Okay. Well, you have a good day. Okay.
Bye.
Bye. Bye. I'll be back tomorrow during business hours to confirm that trespass.
The officers eventually retreated after realizing they couldn't legally detain or arrest him. The man reaffirmed his intention to follow up with the sheriff's office to confirm his rights to access public property. This encounter exposed the officers' misuse of authority and failure to respect constitutional protections, specifically the Fourth and First Amendments. The man left without charges, demonstrating the importance of knowing and asserting one's rights in the face of unlawful police actions. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.
Deal with what you got here for.
You shut up. I'm dealing with this, okay? You're telling me you got permission to be here?
I'm an invited guest. It's none of your business. It's none of your business.
His father is a minor. I'm an attorney because he's a minor. You need to tell me, is he going to be here?
I don't need to tell you anything.
He's being weird right now.
If anyone's being weird, it's the person that rear-ended me and blamed it on me.
Here are moments when lawyers destroys dumb cops.
How is my name going to help you determine anything?
You are an attorney. That's not.
The incident began with an interview conducted by the lawyer's client with KSAT-12 regarding a lawsuit against the Kirby police chief and others, stemming from a land dispute involving private property rights. The Texas Penal Code Section 30.05 specifies that criminal trespass only applies when an individual knowingly enters or remains on property without consent. Both the media and the lawyer had permission to be on this private road from one of the property owners, making any trespass enforcement invalid. Nonetheless, Kirby Police Department was called to issue criminal trespass warnings against the reporters, even though they had no authority on the road.
He never set foot on the property, so that's a false report.
He's not following a report.
Whatever it is, he's alleging that he was on their property and never set foot on it. I set foot on it to get out of there. Yeah.
Again, we weren't here. We can only go off what the TV camera shows. Again, we're not. We don't
look at the
know.
camera?
If they want to show it to us, yes. But at the end of the day, if they put on the property, they have a right to trespass. It's private property. Okay?
How do we get your chief to respond to us? We've been emailing her for weeks about this.
Sir, do you have any ID on you? Because this is a private roadway.
I know.
Okay, can we get your ID then, please?
I'm not talking to you.
No.
I have permission to be here.
By who?
From who?
I have permission to be here.
By who?
By who?
I have permission to be here.
By who?
I have permission to be here.
Who do you got permission to be here from?
By someone who has permission to give me, or has authority to give me permission.
And who is that?
None of your damn business.
Is there one of these residents here?
Yes, it is.
There's only 4 of them.
Yes, it is.
Okay, which resident?
None of your business. I'm telling you, I have permission to be here.
Okay. All right.
You can't trespass me when I'm an invited guest.
You're not an invited guest.
I am an invited guest. How do you know I'm not?
Well,
how do you know I'm not? Then shut up.
I'm asking.
Then shut up and deal with what you got here for.
You shut up. I'm dealing with this, okay? You're telling me you got permission to be here?
I'm an invited guest. It's none of your business. It's none of your business. It is none of your business. It's a civil matter. I am invited to be here.
By who?
By one of the property owners that are abutted along this road. that have a right-of-way and access to this road.
Officer McCleary and Sergeant Lackey from Kirby Police Department approached with the intention of enforcing a criminal trespass order on the reporters and the lawyer. Under Texas Penal Code Section 1.07, a peace officer cannot conduct a criminal trespass enforcement without probable cause or reasonable suspicion of a violation. The lawyer informed the officers that the media and he were legally invited onto the property by an owner. Despite this, Officer McCleary continued to demand identification, which wasn't required without a legitimate trespass order, revealing a disregard for legal protocols. The lawyer asserted their rights, reminding them they lacked any basis to remove them.
By who? By one of the property owners that are abutted along this road.
Okay.
That have a right-of-way and access to this road.
Okay, and just tell me which resident it is?
None of your business.
That's all we got to do. I'll come.
I don't have to do anything to you. I do not have to I do not have to help with your investigation.
Okay.
Now, if you have some evidence that I'm not allowed to be here, well, then by all means, use your reasonable articulable suspicion and your probable cause and do your job.
If you would
Sergeant Lackey,
name, we would let you know.
how is my name going to help you determine anything?
If you are an attorney that's not supposed to be here, then you're criminally trespassing.
I haven't been trespassed from anything.
Okay.
Nobody has presented me with a trespass from anywhere. If you want to show me a trespass, go ahead.
We're working on it. Give us a second.
Yeah, show it to me. I have to be served with a trespass before you can trespass me. Hey, why is Adrian hiding? Why won't he be served? What's Adrian hiding from?
Is that Chad?
No, that's not Chad. Are you McCreary?
Who's that?
I don't know. Are you or McCleary or McCreary? What's your name, officer?
That is Officer McCleary, sir.
McCleary? Oh, you are? Okay.
Yes, sir.
I think you're one of the ones that are about to get added to my lawsuit. Now that I've seen some of the video.
Subsequently, the cops backed off when they knew they can't handle him. He then educates the KSAT team on how to handle trespassing issues.
And just so you know, it's up to you guys how you deal your own thing, but in order to receive a criminal trespass warning, you're not required to identify. You don't have to give them anything.
What if they take us in, though?
Well, they can't take you in unless they trespass you and you refuse to leave. That's when it becomes a crime. Right now, it's just them executing paperwork on behalf of another party. So,
can we pack up and leave?
You can just pack up and leave. Legally.
You get what you need?
You're not being, there's no reasonable suspicion to hold you for a crime. Matter of fact, I'll do the same thing.
As the situation escalated, it became evident that Officer McCleary and Sergeant Lackey were attempting to use their positions to intimidate the lawyer and the media, despite their lack of lawful grounds. According to Texas Transportation Code Section 521.025, officers cannot compel a citizen to provide identification without reasonable suspicion of a criminal act. Knowing the law was on their side, the lawyer informed the officers he wouldn't assist in their investigation, making it clear they were in the wrong. When asked repeatedly for his identity, the lawyer reiterated that unless they could present evidence that he was unlawfully present, they had no right to demand his compliance. Here's another incident when an attorney sued dumb cops.
You please go sit in your car. You have nothing to do with
His
this.
father,
I
he's
understand.
a minor. I'm an attorney. He's a minor.
A highway accident involving a young driver prompted a passing lawyer to stop and offer assistance. Concerned for the minor involved, the lawyer contacted the boy's father to inform him of the situation. When law enforcement arrived, an officer became agitated as the lawyer continued her call, insisting she return to her car. The lawyer calmly explained that she was ensuring the minor's parent was informed, but the officer grew impatient and issued a threat of arrest for interference.
Yeah, the key's stuck.
Are
Okay.
you gonna, so you think he's gonna be taken to the scene or will he just?
Are you?
I'm not, no, I'm on the phone with his father.
That's my dad. But
How many cars are involved right now?
Yeah, mine. That's mine.
All right, we need to get that off the road. All right, can we get that into the parking lot? We'll take care of him, man.
I'm just trying to tell his father. So
we're in the middle of the highway.
Yes.
So,
all right, can you move your car, please? Thank you. My man, is your car drivable?
Yes.
All right, we're gonna get it off to the side of the road. All right.
All I'm saying is I can leave. I just want to tell his father.
You don't have to leave. Just move your car.
I just want you to tell me.
The lawyer attempted to explain her role as a concerned bystander, citing Texas Family Code Section 32.001, which grants parents access to information in emergencies involving minors. Despite her valid explanation, the officer demanded she immediately stop her call and stay out of the investigation. The lawyer's refusal to comply with what she perceived as an unlawful order led the officer to escalate the situation, ignoring her rights and dismissing her attempts to de-escalate.
Are you okay?
Yeah, I'm okay.
Let's have a seat right over here, bro. Is that your mom? No.
You want to talk to someone here? Why don't you talk to someone?
I'm working. Can you please go sit in your car? You have nothing to do with
His
this.
father,
I
he's
understand.
A minor. I'm an attorney because he's a minor. You need to tell me, is he going to be here?
I don't need to tell you anything. I'm going to arrest you in a second if you don't get in your car. Do you understand me? I'm not kidding you.
You are kidding.
You are impeding an investigation right now and you're really bothering me. Go sit in your car. I will talk to him in a minute. Get in your car now!
Tensions boiled over as the officer forcibly restrained the lawyer, causing her visible distress and pain. She repeatedly claimed her shoulder was dislocated during the struggle, but the officer continued applying pressure. Despite her protests, the officer handcuffed her and ignored her explanation that she was acting lawfully as a good Samaritan. Witnesses at the scene noted that the lawyer remained calm while the officer's actions grew increasingly aggressive.
Go sit in your car. I will talk to him in a minute. Get in your car now!
Tell him, take it. No, you do not touch me. Oh my God, stop!
What are you doing?
Oh my God,
What are you
stop
doing?
it! Are you kidding me?
Knock it off!
You will be.
Knock it off!
No, you get your hands off me
Knock
right now.
it off.
Get your hands.
All right. Yes.
Tell him to get his hands off
Yes,
me.
I do.
Tell him to get his hands off me right now. Oh my God! Are you
Stop!
fucking kidding me?
Stop!
No, I'm not stopping. Are you fucking kidding me, right?
It's recording.
Record it.
I'm wearing a body cam.
Record it. I understand, but why am I under arrest?
Because you weren't listening to anything we were saying.
Oh my God! You're not listening to your father or something. Oh my God! Look, okay, I will come down. Can you please?
Take a breather.
No, you don't take a breather. I'm fine. Like, I'm right now. Can you just let me
Not
move my
bleeding
arm?
at all.
I just moved my arm so it doesn't hurt. I'm sorry.
How about you stop resisting?
And
you let us put you in handcuffs.
My shoulder is dislocated and you're making it worse.
Well, rescue
Can I
crew will get you.
please? Yeah. Oh my God.
Sit up.
Can you please call Bob Barber?
Sit up.
Call Bob Barber right now.
Who's that?
He's in Narragansett, please. Please call him.
Well, we're not in there again.
I understand that. I cannot believe you. Take this fucking off me right
Okay,
now.
50. I have one in custody,
Oh my
disorderly
God.
and resisting.
Oh my God. You gotta be kidding me. You gotta be kidding me.
Stop.
No!
Stop talking.
No! No! This is so ridiculous. I cannot even believe this. Oh my God.
Go put her in my car.
I just wanted to know. I could tell his father if he was going to the hospital. I'm not even involved in this. I can't believe this.
That was our point the whole time.
I cannot believe this.
That was our point the whole time. You are not
screaming at me.
involved.
Oh
You
my
are not
God.
involved.
I'm a good
We
Samaritan.
instructed you to do something,
I'm a good
and you
Samaritan.
refused to do it.
I'm a good Samaritan who stopped to help a kid, and this
Let's
is
go.
what happened. Okay, stop grabbing me. I'll get up on my own. You're hurting me.
Now.
Oh my God, stop it. Ow! Ow! I want my phone. It's over there. What am I doing? He's pulling my... Hey, stop. Get my shoe. Please get my shoe.
Okay, walk.
Get my... Oh my God. Oh my God. Oh my God. I cannot even believe this. No. This man is beating the shit out of me. Holy shit. Yes, he is. Oh my God. Oh my God. This is the crazy... I've never... Stop pushing me, please. I will walk. Are you kidding me? You guys don't know how much trouble you're in. I'm gonna see you so I know. You're in so much trouble. I can't even tell you. Oh my God, this is the craziest thing I've ever in my entire. I'm not gonna relax. I can't. I don't have to. You guys, where do you get this machismo shit? This is bullshit. I need my phone. It's on the ground over there.
I will grab it.
Call my husband. He's also an attorney.
Go ahead, get it.
This is so bad. Yeah. I can't even.
The phone's right here.
Oh, right.
The lawyer was placed in a police vehicle, with officers refusing her requests to retrieve her phone and contact the minor's father. They justified their actions as maintaining order but made dismissive remarks about the lawyer's resistance, ignoring her rights and her role in assisting the minor. The treatment she received highlighted a concerning disregard for lawful actions and the rights of bystanders trying to help in emergencies.
Find her key, but the car started up, so it's in there somewhere.
Key's probably on her.
Would it start up from like, yeah? All right.
If the car's on and running with the push to start, the car's on and running, it will run as long as the key's in a certain distance, which this is probably a certain distance. Now you
Did you take a key off of her?
Her?
Yeah, when you, I didn't either.
Did you put grab her pocketbook and everything?
She didn't. She was just out of the car. All we have is her cell phone, a shoe, glasses.
That's it. The key's either on her person, most likely, or the key's in her pocketbook. Does it say key not in vehicle?
No, because it started right up.
Right. So the key's in the car.
Yeah, I just couldn't find it.
Oh, that's probably like a cup holder or like a...
All right, you want me to move his Volvo?
Hey, well, can't move it. It won't go. I would have moved it. Why don't you bring her back? It started before, but why don't you bring her back? Get her out of here. Get her. I'm assuming if she's an attorney, she's got nothing. We'll get her when she cut her loose. Right. And then go from that. Right. Yeah, I heard you guys say one in custody. I'm like, here we go.
It was so unnecessary.
Yeah.
But like my tolerance for that is like, I'm just like, listen, if you're not going to listen to what I'm saying, we're in the middle of a highway. Yeah. Get in your car and get off the highway.
I fucking stood her up too. She started screaming like belligerent. The kid was even more freaked out than anything. How old's the kid that was? I don't know.
05 is his birthday. 17.
Determined to seek justice, the lawyer filed a lawsuit against the officer and the department for excessive force, unlawful detention, and violation of her constitutional rights. Her legal claim emphasized her lawful status as a good Samaritan and her right to communicate with the minor's parent. The case aimed to hold the officer accountable for his actions and shed light on the importance of respecting citizens' rights, even in high-pressure situations. Talking about accidents, here's an off-duty cop who thinks he's smarter than a lawyer.
Question, right? I'll take the blame.
It was a dumb question. It was a question, but it was a dumb question.
This situation unfolded when an off-duty police officer rear-ended a lawyer who was stopped at a red light. The officer, instead of acknowledging fault, tried to place blame on the lawyer, suggesting that he had somehow backed into him. Texas Transportation Code, Section 545.062, makes it clear that the driver who rear-ends another is typically at fault for failing to maintain a safe following distance. The lawyer, taken aback by the officer's accusation, recorded the interaction, ensuring an accurate record of what was said.
No, you hit me.
I did? I was on the brake.
Yeah. How dare you blame it on me?
Huh?
How dare you blame it on me?
Yeah, we can exchange information. That's fine. You want to get on the roadway?
Yeah, as soon as I get your license plate number, meet me in the subway parking lot. I'll get your insurance information.
There's no damage though.
I see damage. Well, we'll check it out at Subway.
There's no damage.
That's fine. We'll check it out in Subway. Can you meet me there, please? Don't drive away. I got all your information.
I'm a police officer, so I'm not going to drive away.
Well, I'm a lawyer, so meet me in Subway, please.
From the start, the lawyer recognized the importance of having solid evidence, such as dash cam footage, to document the circumstances of the collision. According to Texas Insurance Code Section 542.003, insurance companies must consider all evidence when assessing claims, and having video proof can significantly impact liability decisions. The lawyer's dash cam footage was key to countering the officer's claims, capturing the scene and preserving evidence in case the matter went to court.
Are you drunk or what?
What?
Are you drunk? Okay. Get your information anyways.
What?
Your insurance card?
Yeah,
please?
do you have your notepad or something or something to write it on?
Yes, it's recording right now.
You ready for it?
Yep.
My policy number is 041 C as in Charles, 7 wine, 7. It's
pretty cool. You did read it like a police officer. Can I get a copy of that or something?
You don't need a copy of it. You just got a policy number.
Okay, then
and have my name and number as well.
Can I record that screen?
Yeah. So I'll write everything down for you.
What department do you work for?
I'd rather not say. Because you're being weird right now.
How am I being weird? You just rear-ended me and I'm recording it for
I'm sorry.
evidence.
I don't remember.
Do you have body
anything,
cams when we're at your work?
No, I don't.
Throughout the interaction, the lawyer stayed composed, questioning the officer's version of events. The officer made various statements, first claiming that the lawyer had backed into him, then questioning if his own foot was even on the brake. The lawyer pointed out these inconsistencies, noting that such contradictory claims demonstrated a lack of personal accountability, particularly inappropriate for someone in law enforcement. His calm responses placed pressure on the officer to reconsider his position.
Weird. You just rear-ended me and I'm recording it for evidence.
I don't remember.
Do you have body cams when we're at your work?
No, I don't.
Well, you should get body cams. Most police officers do have body cams. There's nothing wrong with documenting a car accident. You should know that as a police officer.
Yes.
Okay. And if anyone's weird, it's the person that rear-ended me and blamed it on me.
What?
I said if anyone's being weird, it's the person that rear-ended me and blamed it on me. Like, did I hit you?
I asked you the fucking question. If you rear-ended me, or if you fucking ran into me. It's just a question, all right? I'll take the blame. I don't
It was
care.
a dumb question. It was a question, but it was a dumb question.
It was a reasonable question because I don't remember. I had my foot on the brake. I don't remember hitting my
your
foot
foot
back
on the
in.
brake? Yeah. Okay.
The officer's shifting explanations quickly unraveled, leading him to admit fault after the lawyer pressed him to clarify his account of the incident. Under Texas Penal Code Section 37.02, knowingly providing false information, especially in a way that could mislead others, reflects poorly on a public servant's integrity. The lawyer emphasized that it's essential for officers to uphold high ethical standards, which includes immediately taking responsibility for mistakes instead of trying to shift blame. The lawyer's calm demeanor ultimately led the officer to acknowledge the truth.
Here, my name, address, number. I need yours too.
Yeah, I'll just give you my bar card. Bar card.
What? Because you're being weird right now.
If anyone's being weird, it's the person that rear-ended me and blamed it on me. Like, did I hit you?
I asked you the fucking question. If you rear-ended me, or if you fucking ran into me. It's just a question, all right? I'll take the blame. I don't
It was
care.
a dumb question. It was a question, but it was a dumb question.
In the end, the lawyer made it clear that he held no grudges against the officer, viewing the incident as a learning moment. Dash cams, he noted, are invaluable tools that provide an objective account, protecting all parties in a dispute. For law enforcement, such situations highlight the importance of body cameras and maintaining professionalism, even when off-duty. By standing his ground and relying on evidence, the lawyer underscored the value of honesty and accountability, especially when it involves an officer of the law. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.
I'll tell you this because I'm a lawyer and I've studied this. I'm not going to come out here without knowing the law.
Hey, get your hand off of me. Get your hand off of me.
You're next as well.
Unconstitutional detention, and I want him arrested for unlawful detention and battery.
Up to the meeting's closed. All right?
The public meeting is closed.
The state fire marshal's decision to host a public meeting in a room with a capacity for only 40 individuals created a legal problem. Under the Oklahoma Open Meetings Act, all governmental entities must conduct their public meetings in a manner that ensures transparency and accessibility for citizens. The failure to accommodate the public violates this act, as government officials cannot restrict access to meetings that determine public affairs. A simple solution, such as live streaming the event, could have prevented this issue. However, officials chose to limit participation, prompting legal concerns over citizen rights being disregarded.
The meeting's closed. All right?
The public meeting is closed.
Stop talking.
Okay.
As long as everybody wants to behave and act orderly and not get out of control and be disruptive.
What does that mean?
Stop.
Can you give us a definition of
You're
that?
welcome. Are you serious?
Yes, I need a definition.
All right, you're
of that.
welcome to stay right here. At some point, if you become disruptive and disorderly, then that becomes different. Does that make sense?
No, it doesn't make sense at all.
Good. I've totally explained myself.
No, you
All
don't
right?
make sense at all,
Don't cause us to come back out here.
I would stay away from this guy because he's probably going to get you guys all in trouble if you
we need
listen
to file a police report, sir.
All right.
Related to the violation of the Open Meetings Act. And I also need to place him under citizen's arrest.
You need any help?
You're not doing that? I need to file a complaint against you for dereliction of duty then, Master Sergeant.
I'll just take care of that. All right, we're getting out of here. If you need help, call us.
Do you have a report number?
No, that's why I requested a report number.
You're not going to issue us a report number? So that's dereliction of duty. You understand that, right?
The refusal of law enforcement to acknowledge a citizen's request to file a complaint further highlights their dereliction of duty. Title 22 of the Oklahoma statutes allows citizens to initiate a citizen's arrest for violations of the law. When the attorney attempted to exercise this right, officers ignored the request, dismissing the citizen's legal authority. This disregard escalated tensions, with one officer unlawfully detaining the attorney without reasonable suspicion or cause, further infringing on the attorney's rights.
Hey, get your hand off of me. Get your hand off of me. Well, they won't let you in the public building to do that, so. Why did you touch me?
You follow me to my car, you're going to sit in the back seat of my car, and I'm going to make sure you don't get any more.
So you're as a threat of arrest? I don't have the. So you're telling me if I follow you, I'm going to be arrested? You don't have the right to check me for warrants. Do you have reasonable articulable suspicion that I've committed a crime? You do understand I'm an attorney, right? You understand that? Bar number 2, you might want to check yourself. I know this a little bit better than you do. Have a good day.
You gonna walk away, or what are we gonna do?
I'm gonna stand right here.
Okay, we're gonna check, make sure you don't have any warrants.
Okay. Wherever you tell me.
Got any ID on you?
I do.
You're next. You're next as well.
Why am I arrested?
You're not arrested. I'm gonna see who you are. Since you're being
right
disruptive.
pocket. Right pocket.
Where's your ID at?
Right pocket.
I'm gonna take that out and get your ID out.
It's on the left-hand side, very top, right behind that blue card. Not very top, that's one more, that's behind the blue debit card.
After I handcuff him, I'm gonna, each one of you guys are gonna come over and sit in my car. We're gonna make sure you don't have any warrants. Okay? So this is your chance to walk away, just like I told this
Walk
gentleman.
further back. Walk further back.
Slide this way.
Yes, sir.
Stay right there.
You're having a really bad day. Look your body.
The attorney was subjected to an unconstitutional detention when an officer insisted on running a warrant check without probable cause. According to the Fourth Amendment of the U.S. Constitution, a person cannot be detained without reasonable suspicion of criminal activity. The attorney reminded the officer of his professional standing, stating, "I'm an attorney," and explained the lack of legal grounds for the detention. Despite this, the officer insisted on detaining him, exemplifying an abuse of authority and a failure to uphold constitutional protections. The cop eventually released the attorney after a display of power trips and rights violations, leaving the attorney furious and determined to pursue legal repercussions.
Hold me. But it was all live streaming, so that's awesome. Thanks for that one.
Yeah. Oh well.
Amazing shape, but let me borrow that.
Woo! What a day!
Oh my God! I mean, it's like constitutional rights galore. Hey guys, officers, I did not get his name and badge number. I need to file a complaint. How do I do that? Yes, absolutely. I just need his name and badge number so I can go to the police department and do that. If you can just direct me where to do that. I was maintaining distance. He could not articulate a crime for which he was suspected. He wanted to run me for warrants. Is the reason he detained me. That is an unconstitutional detention, and I want him arrested for unlawful detention and battery. So I'd like to file a report. I know the supervisor's coming. That's perfect. He way screwed up. No, man, he's got an attitude problem. He's got an anger problem.
Yeah, like when I said good morning to you and your name, you just smiled and said good morning. He literally, that's all I did. He walked up, I said good morning, Higginbotham, and he goes,
patrol. I'm good. I'm a patrol guy. When we were going to the building, he said you can't go into the room where they're having the meeting. So I'm walking into the building, and he grabs me, like pushes me, and we're like, hey, whoa, it's okay. But we have a cordial conversation, no problems. Higginbotham comes out of there like a daggum tyrant for us. And this is as excited as I've gotten today. I can get excited, but I've not even been excited. And yeah, he wants to check me for warrants. And then he's like, "Oh, you sure Tulsa doesn't want him?" Like that man was trying to find some reason to take me down to the jail. And I told him I was just there on Friday for disturbing the peace at Tulsa County Courthouse. So I knew I didn't have any warrants. I was just in the courthouse yesterday passing out StopSharingHomes.com stuff for the drunk driving judge we've got in Tulsa County. I'm a lawyer. I do this. I kind of know a little bit what I'm doing. So I'd like to citizens arrest him, that officer. Okay, well, I'm going to citizens arrest him for unlawful detention, battery, assault, intentional infliction of emotional distress, what I'm going to sue him for on top of my civil rights violations, 42 U.S.C. 1983. But, we'll wait. That's what I do for a living. I do civil rights for a living.
You've had your opportunity to talk. Will you give me a minute to talk?
Yes, sir, absolutely. I will.
So I'll tell you the reason that we got called out here was somebody from, I believe, your organization, where she's blonde.
Yes, she wanted file a report.
Yeah, she wanted.
And that officer wouldn't give us a report. So the Open Meetings Act is the violation of the Open Meetings Act, which denied the public access to a public meeting, which is what that is. You can't restrict it on the basis of you've got 44. Otherwise, the government would just put in a room of 10 people and you'd never have open access to government meetings, right? There's rules that very clearly state that if you can't have the public accessible to that, then what you do is you can stream it live. We had all these COVID things that changed where we can just live stream it as long as you can hear everybody, the public's aware. They're not even public comments, so they don't even have to entertain people to say something, right? All they have to do is let everybody see it.
Would you get?
No, he won't give us he wouldn't give us a report number. And that was the problem. We're explaining, hey, we just want a report number because it's a violation. And as I explained to him, as a citizen, we have the right to a citizen's arrest. I explained to him the statute under Title 22, and I said I'd like to exercise the right for y'all to cite them for this violation so we can get some kind of case started. He just gets absolutely irate, and I say, officer, if you're not going to do anything, that's dereliction of duty.
This dude's been rock solid and chill since he rolled
up. And I'd like to file a complaint against you, and I'd like to file charges against you for dereliction of duty. And that's when he got really pissed off.
And they love to work with us, like the one at the yesterday.
He was good.
Oh yeah, dude, he was awesome with us.
The United States Constitution, the United States Supreme Court.
I don't know. This whole week's been a blur.
I know, me too.
Public sidewalks are open public forums for the purposes of gathering, and I can yell as loud as I want to, as long as I'm not using a noise assistance device. In the specific case of standing outside of a courtroom for the purposes of disturbing a judicial process, I can yell outside of any other government building as loud as I want to. Right? I mean, so, wow, guys, wow. Lieutenant.
If you'll give...
yeah, y'all talking. We'll give you a minute. Yeah.
If you give me a few minutes,
yeah, hey, by the way, y'all pass this around. You should check it out.
You should definitely check. If you care about your job, you should care about the video.
I mean, this is a drunk driving judge.
Yep. Yeah, you should definitely watch it. At least make sure your people and your boss got that video.
Yeah, make sure your people know.
It's a good learning video, if anything.
Yeah.
A good learning
video. It really is. And look, y'all just got to watch me get detained unconstitutionally, and I mean, it's all on FX3, Sony FX3. We should have had me mic'd up, man.
We should have. I thought about that the one time we did.
Body mic going. I didn't say much in the car anyway.
Smart move.
I was just quiet, watch it, smile.
How many times is that?
Next time.
No, it's only once.
Hey, next.
How did it go? What happened? Hey, can somebody give us an update of what happened in that meeting?
When we got here, we were here a little bit early, before 10. They let us know they were only going to allow about 49 people. I then let Ron know, hey, you guys, they're not going to let everybody in. I let them know at the front door that there was going to be a problem, that 2,100 plus businesses have been issued this letter and they have something to say, and that there was going to be a lot of people that were denied access to this meeting.
The The attorney maintained composure while asserting his legal knowledge and defending his rights. Under 42 U.S. Code Section 1983, individuals have the right to seek redress for civil rights violations by government officials. The attorney openly declared his intention to pursue civil action for unlawful detention, battery, and intentional infliction of emotional distress. By citing relevant laws and refusing to back down, the attorney set a precedent for holding law enforcement accountable when they violate fundamental rights. This case highlights the necessity of being aware of and standing up for one's legal protections. Just like this incident, here's a Christian lawyer who refuses to be intimidated.
I'll tell you this because I'm a lawyer and I've studied this. I'm not going to come out here without knowing the law.
The incident began with a discussion about the volume of amplified sound used by a preacher on a public sidewalk. The officer stated disorderly conduct for unreasonable noise could apply if the volume exceeded acceptable levels. However, the preacher, identifying as a lawyer, argued that amplification is constitutionally protected under free speech. He further clarified Arlington doesn't actually have a city code for noise, except for parks and recreation areas. This ensured his compliance by reducing the volume slightly while emphasizing his legal right to amplify his message in public spaces.
So we understand that you have the right to be out here, you know, freedom of speech, all that. We're good with that. All right. This is public property. So where you're at, you're not obstructing the sidewalk. All right. So we appreciate all of that. Right. We have had complaints on the volume. Okay. So we've made the determination that we're not going, that you can have some semblance of amplified sound, but whenever it becomes excessive and people are complaining that you're hurting their ears as they're walking by, that is excessive.
Turn it down some.
So if we can turn it down,
absolutely,
that would be the best part about that.
I'll turn it down some.
Did you want to issue a criminal trespass for Cowboys property, or did you want to?
What's public property?
Well, I make a phone call.
Okay.
Run it up. I know you're out here earlier.
Yeah, man.
So
on a public sidewalk. Yeah, I didn't step on your property.
So at first you were over there with you were actually on Cowboys property, from my understanding.
Yeah.
Well, then you moved, and then you were on the sidewalk. Is what I didn't see it all. This is what's being relayed to me. Okay. Then you were on the sidewalk and you were blocking the sidewalk, but then you moved from there, so therefore you're okay. Right?
When I came here this morning, there was no one here.
Okay.
I was here like at 10 in the morning.
I got you. I said I wasn't here.
Sidewalk.
Yeah, chalk.
Yeah.
It's like children's chalk.
So
it's going to rain. It's going to be gone.
So the big deal on this is we got to lower the volume, right?
I can lower it.
There's disorderly conduct for unreasonable noise.
Well,
right?
There's always decibels that I go by.
Well, but whenever someone's walking by here,
they don't.
I could probably take a decibel reading.
That's what I mean.
Right here beside your speaker, if you want me to.
Yeah.
And
I can turn it down because I want to comply with you guys.
No, I got you. From where?
But I don't want to be to like such a low level where like it's like.
I understand that. So, but like I said, from whenever I rolled up here, I could almost guarantee you if I would have pulled out a decimal meter right then, you would have been well over that. So
I'll turn it down some.
So
work with you guys.
let's do that. Let's turn it down. It's their option, okay? As Cowboys.
Well, if they feel unlawful, sorry.
I'm saying, so if you were over there,
they want to get sued. That's
right.
Fine.
So they can issue a criminal trespass warning, which all that just means is that you can't come on the property, right?
The officers attempted to link the preacher's activities to nearby private property, specifically Cowboys Stadium. According to the preacher, "I never stepped on your property. I've been on the public sidewalk the entire time." The Texas Penal Code section 30.05 regarding trespassing highlights that an individual must physically enter private property after being explicitly warned. The preacher remained on public property, defending his right to be there, while the head of security acknowledged his compliance.
I'm not on the property.
You're not on the property. Not right now, you're not. You know what I'm saying?
And on my sidewalk, I'm not on the property.
I'm not arguing with you.
I can show you the pictures.
I'm just letting you know that if that's what they choose to do, we're going to do a criminal trespass warning, which means that there's no action being taken against you other than the fact of them officially saying they don't want you on their property.
That's right.
And as long as you don't go on their property, then there's no issue. Right. So cool. So this he's the director of security. Okay. So he'll make that determination on whether that's what they want to do or not.
Sure.
But in the meantime, we're going to turn down the volume just a little bit for us.
A little bit. Yeah.
And as long as we don't have any complaints or anything like that about
that's the volume. Problem because amplification is actually constitutionally protected.
It is.
It's established. So it's not really disorderly conduct. Disorderly conduct would be if I'm inciting, I'm calling people to violence.
There's an unreasonable noise level that
not for Arlington.
That we'd have to pull that up and everything like that. But
yeah, Arlington. Well, I'll tell you this because I'm a lawyer and I've studied this. I'm not going to come out here without knowing the law. So Arlington doesn't actually have a city code for noise. They do for parks and recreation. That's the only. So if I go to like a public park and I'm doing this, then there's like decibel readings and there's all this. It's kind of a weird law, but I want to work with you, so I'm willing to turn it down some. I don't want to be like drowned out.
No, I hear you.
Then,
I hear you.
But no problem.
You're out here for a purpose.
Yep.
I understand that. But so let's see what they want to do. So if you
I got pictures too. If you want of the chalk, it's on public.
That doesn't bother me.
They already washed it off. That's in a little.
I'm not concerned about the chalk at all. So okay,
I know you're responding to
that's
that.
not an issue right now. So we got calls from people that were walking by.
Sure.
They were reporting that they were being disturbed by it, which I understand. There's a level of
chalk.
No, not the chalk. I'm talking about the volume, the speaker. So.
The preacher addressed complaints from passersby, stating content-based restrictions on speech violate the First Amendment. He argued that complaints about his message being disturbing were tied to its religious content, not its volume. He further explained that expressing a neutral message, like praising Kenny Chesney, would not result in complaints, proving a bias against his speech. The officer acknowledged this distinction, agreeing to work within legal boundaries while ensuring public order.
Well, that's what I mean, like being disturbed. That's not disorderly conduct.
I understand. There's a balance in there, right?
Well, there's a constitutional balance for free speech.
Right.
So there's not a heckler's veto.
Right.
Like if I was out here just saying, hey, beer's awesome, man, Kenny Chesney's awesome, you'd get no calls, right? So because it's content-based, then it becomes something else.
Well, yeah,
because they don't like the content of what I'm saying.
I understand.
My volume like this, I guarantee, if I start saying Kenny Chesney, ooh, you get no phone calls. So because of that, it becomes content-based. But I'm willing to turn it down some.
Okay.
But like I said, I don't want to get tangled up with legal stuff. I've done it in the past. Right. It's a pain in the butt.
And that's not what your purpose. Your purpose isn't to go to court and fight tickets and do all that kind of business. Your purpose is to get out here and get your message out. So
I'll turn it down some.
All right. So.
Wow, that's pretty loud.
Did that hurt your ears?
A little bit.
Come on, man. You ever go in there? It's pretty loud.
I've been there all the time.
A whole lot louder than this.
Part of the reason why my ears do hurt.
All right.
Yes, sir.
Well, I mean, there's earplugs. I mean, he doesn't have to stand on it. That's no legal basis for it. But I will turn it down. So, all right, so I'll show you I'm doing it. Right now it's on -10 decibels. All right, so I'm willing to turn it down to, I'm going to try that. See how that works. -18.
Okay.
I'll even go a little further. -20.
Check. Okay. Check. That's it.
That's cool.
As of right now, to me, that seems reasonable.
Doesn't hurt your ears. You're not like,
No, and the speakers aren't facing me.
I get it.
Either,
yeah. I try to be considerate. I don't want to be blasting people's ears either. I got some hearing damage from the military when I was in.
Cool. All right. Well, just hang tight. We'll find out what it is. If they don't want to do that, then we'll get out. You're right. You are in a public place right here.
Yeah.
So,
and I didn't draw here. I know this is kind of their turf.
Right.
It was on this sidewalk, but on that side and on that side.
So here's my ask, and I'm the director of security for the building. Volume.
Sure.
Dial that down.
Yeah, turn it down. You saw it.
Okay. Yeah. You've got.
No worries.
Plenty of rights to be out here. Obviously, there's an event that people, and where it kind of comes into is for the stadium, we've got tailgating policies as well. Yeah. There's amplified sound that we focus on when it comes to whether it's the person who's over there in a tent, dialing that down. So that's going to be my ask.
They're paying to go in there, right?
What's that?
They're paying like a tailgating fee and all that.
Yeah.
They're under your all's policies.
They pay for the parking. Yes, sir. Yes, sir.
I'll work with you guys. I'm not here to antagonize anybody.
Yeah. From my side, I would make the ask. If you wouldn't mind moving someplace else, not on property, you are within. Again, this is me asking as an individual.
Yeah, I got you.
Again, that's not anything that you have to do. You have the rights.
Sure. Well, I'm going to be here then until your show starts, and I'm leaving. So it's 4:30 right now.
Yeah.
Is that cool?
It's cool. Again, my ask would be that you do move along.
It's going to take a long time for me to break it down, and by that time, all these people are going by. Like right now, I came to appreciate the people, but you guys are, quite honestly, I'm trying to be respectful.
Sure.
We're good. All right, we're good. I turn it down.
Yep.
I'm not chalking on your sidewalk. Actually, it's public sidewalk, but I'm not chalking on it. I get it. Some people don't like the message, but it's kids chalk. So it's gonna, the next rain comes, it's gonna vanish.
Sure.
I get it. You got a job to do.
Yeah, but aesthetically, we had to have housekeeping come out, which spent time, money, individuals.
That was your choice. I didn't make you guys do that.
To be able to get out and clean that, because there's a look, there's appearance at the stadium we try to hold by.
In the future, I want red on that sidewalk.
Thank you.
I'll choose other sidewalks. It's not AT&T.
Correct. Nor was I stating that.
Yeah. Not this vicinity. I got it. That really pissed off your, pardon my language, that really upset some of your security people. And they were quite wild with me in doing that. So I would, if you're the head of security, I would be concerned with my employees being vile to not tax-paying resident citizen of the United States in Texas.
And I can definitely address that. And it is, whether it's you with this message, whether it's somebody else with another message, or individuals selling things, this is a very standard procedure that we do come across as we host events, as people pay to come to these events.
They're not going to stop paying either.
The thing, but again, the message to you is no different, whether it be to you, to another individual with a different cause, a different purpose. It is standard policy that we do address this with said individuals. We do ask other individuals if they could, if they would move on to another location.
What's your name? My name's Gabriel.
My name's Brian.
My name's Gabriel. Thank you, Brian. Officer Paul. Paul. It's a great name. God bless you guys. All right. Any more issues, just come up.
Now, okay?
Just let me know if there's any more issues.
He turned the volume down. It was at a -10. Now it's at a -20.
Okay.
So hopefully that'll be good for everybody.
Praise God.
All right.
About 30 more minutes, I'll be out of here. Thank you, sir. God bless you.
The lawyer demonstrated a cooperative approach, turning down the volume and offering to adjust his activities to avoid unnecessary conflict. The Arlington Municipal Code allows such peaceful resolutions provided no laws are violated. Despite previous hostility from some security personnel, the preacher reminded the head of security to ensure his employees maintained professionalism. By standing firm and informed, he maintained his rights while respecting lawful authority, reinforcing that knowing the law is crucial in protecting one's freedoms. Like and subscribe for more police cam stories. Watch the next recommended video. Click to watch now.